All on the list, please.
Original site, commercial division, day list, restoration application, item number 1, Raj Money versus Tata Motor Finance Limited.
Lord, I am appealing for the applicants. Milord,
I'm appealing for the response.
The last officer, my was having kind enough to direct my clients. The applicant is serve notice upon the response.
Respondent is here, just tell me.
Milord, because this is application, registration application of 65 days delay. For registration and the grounds we have taken. The initial if one was is the paragraph 3 of my registration application, Milord. But the initial
No, let me read it, please.
Fine.
Paragraph 3, and which
Paragraph-
other paragraph?
and paragraph 3 and
Not aware of the petition. Who was not aware of the petition? What
No.
about the advocate on record?
yes, Milord, that is the main reason the advocate Mr. Anand Farmania, like who was not.
Which other paragraph?
Yeah.
Yes, what do you have to say, Mr. Chaudhary?
My lord, in case of restoration, I will not stand in the way, but your lordship has seen the delay he has committed. So your lordship may impose cost to some charitable organization as for your lordship's choice. That's my number one. And
Not for you.
no,
That's
I'm
what you
not-
mean to say.
I'm not asking. Number two, my lord, my second submission is this: in case my lord is to pass an order allowing this petition, perhaps he has not paid full court fees.
No, that is a later thing.
Let's.
Yes, the application is for recalling an order passed by a coordinate bench on 1st May 2023, dismissing the arbitration petition. Stop. The learned judge was of the view that the petitioner is not interested in pursuing the litigation. Stop. Next, the grounds given for the non-hyphen appearance of the advocate on record on that day are considered to be sufficient. Stop. GA1 of 2023 is accordingly allowed and disposed of by recalling the order dated 1st May 2023 and restoring the arbitration petition to the original file and number. Stop. Next, the delay of 65 days is condoned. However, the petitioner shall pay costs of blank to be paid to blank within 7 days from date.
Grateful to your lordship.
Next.
New motion, item number 2, GTZ India Private Limited.
But I appear for the applicant. This is an application for revocation of a patent.
Microphone, please.
This is an application for revocation of a
Where
patent.
is the prayer?
Prayers are at page
101.
yes, ma'am, 101. The patent there were 2 patents which were granted. We have filed revocation against both the patents. Only one of them is
No, it's
appearing.
a rectification as well.
It's a post-grant revocation and rectification after the revocation.
And when was what is the date of the grant?
It was granted on 13th June 2023.
So
At paragraph 22, the details are given.
Patent for?
This is a product by process patent for the product ferric carboxymaltose, the product which is used for treating anemia.
Product plus
No, it is not the
process.
product. There is no patent over the product. It's a product by process. Only the process is patented. Even though my learned friend, the patent holder is claiming over the product, but that is not the case. It is only the process by which, of which my learned friends have got patent.
The patent holder is respond number 1.
No, I have, yes, my lord, we are from the respondent number 1, man. My lord, small instances, my lord, Mr. Sarshi Dasgupta is.
No, 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 please don't take adjournment. No adjournments in this court. Yes. Yes, Mr. Roy Choudhury.
Yes, my lord. So at this point of time, perhaps there's no
Microphone,
scope
please.
for, there's no scope for any interim order, my lord. Because my
Yes,
learned friends have-
Mr. Bhattacharya, you're for who?
For the controller, my lord. Respondents two and.
Yes, Mr. Dashgupta. Can't hear you. Microphone.
We would like to file an affidavit because this proceeding has been filed pursuant to a suit that we filed against the petition.
Infringement.
Yes. After that, they initiated.
And have you got any order in the suit?
No, my lord, it's being heard. It's
No
being
order
heard.
in this.
It's being
It's,
heard.
it's being heard.
Yes.
It's been heard since when?
There are two hearings
No, it
after
hasn't
their
heard on-
direction for affidavits. So my lord, they are filing the affidavits and they have also taken out an application for revocation of the leave. So we are at that stage, my lord.
Revocation of leave,
Yes, my lord.
Granted under
Commercial.
commercial 12,
12.
12A. Very well. How much time do you want for your affidavits?
Kindly give us like 4 weeks time because this is the first time they challenge this particular patent. So,
How many times do you expect them to challenge?
no, my lord, in this suit, if they had disclosed their defense, then I would have known what their defense would be. Here, my lord, kindly gives us 4 weeks time so that we can, my lord, it's a long
My lord, writ of
petition
summons
also.
have not been served in the suit, my lord. How can I?
But the petitions are with them.
That I have already done.
Very
That
well.
has been
Yes,
filed.
Mr. Bhattacharya.
4 weeks we will require.
So there are 3 respondents. Who's for the,
Ma'am.
you're appearing for 2 and 3,
Yes.
Mr. Bhattacharya.
Yes, my lord.
Very well. This is an application for revocation of a patent granted to the respondent number 1. Stop. The patent is on the process for manufacture of, what is it? It's a medicinal patent.
It's a product by process patent.
My lord,
What is a product?
It is it's
Medicinal.
ferric carboxy maltose. It's one of the elements which is used in medicines for treating anemia.
Yes, ki bola? The patent is a product by process. That's the way it's called?
Yes.
Product by process patent. Product by process ta quotation marks de do. Product by process patent for chemical substance used
My lord, may I? My lord, it is called an active pharmaceutical ingredient.
for an chemical substance keda do, for an active pharmaceutical ingredient used for treatment of anemia. Stop. Next. The respondent number 1 is the grantee of the patent, comma, the respondent numbers 2 and 3 are the controller of patents. Controller of patents capitals. Stop. Next. Affidavits in opposition, comma, as prayed for, comma, within 4 weeks from date, reply within
The 3 weeks.
3 weeks thereafter. Stop. You get to 2024 or 25?
My lord, still in 2023.
7 weeks will take us to
After the vacation.
for sure after the vacation. I'm talking about the winter vacation.
10th of October. With 10th of November.
10th of November, 7 weeks.
7th November.
Very well. List this matter on 29th November, 2023.
Great.
Item number 3, Pratyusha MRJV 3 and 4.
My applications.
Yes, yes,
My lord, we had filed our notes.
yes.
Lordship, and has any query, my lord, we'll answer, my lord.
Thankfully, in this matter, no. Learned counsel appearing for the parties have already indicated their, have already filed their respective notes, capital N, stop. List this matter on October 2023 under the heading for judgment.
Great.
Are you enjoying an interim order, Mr. Shah? No, there's no interim.
No.
Yes. It's an 11 and a 9.
11 and 9. Very well.
You wanted to say something, Mr. Shah?
But I was wondering if your lordship would be minded to keep it on the 6th.
6.
Or
I will be just delivering judgment.
Well,
I
well,
can keep
yes.
it, tell me a date on in the first week.
3rd, 4th and 5th, my lord, I am a little preoccupied, but any day other than that, my lord, that suits your lordships, then the court's.
6th.
So obliged. Item number 5, SK International.
Let my application under section 11, my lord. Contract date.
1 minute. Can't you see I don't have the papers?
I apologize.
Are you disputing that there's a dispute?
Lordship, there is a dispute.
Microphone.
Lordship, there is a dispute.
There is.
There is a dispute. The arbitration clause says sole arbitrator. They've given a notice under 21. They've nominated a person. We do not agree to that. The only thing, your lordship, the only thing, if your lordship kindly considers is a technical point, your lordship, the statement of truth is not there, your lordship.
Statement of truth.
Lordship, order 6, rule 15A, 1 and 4, your lordship says.
Under the Commercial Courts Act,
Lordship,
as amended now.
Lordship.
Yes.
that
Yes.
every pleading has to be.
Order 6, rule 1 says pleading shall mean plain or
1
written
minute, 1 minute. Commercial Courts. Yes, order 6.
Rule 1, my lord, pleadings shall mean plain or written statement. Lord, these pleadings in a commercial dispute has to be supported by a statement of truth. Lord, this is an application. This is neither a plain nor a written statement. Only for a plain or written statement,
1
there
minute.
has to be.
Order 6, rule 1 doesn't say anything about statement of truth. Where is it?
No, my lord, order 6, rule 1 says pleadings. Pleadings shall
Yes.
mean plain or written statement.
15A, your lordship. Yes. 15A1 and 15A4.
Let 15A, if Let 15A says verification of pleadings in a commercial dispute. Pleadings should mean only plain or written statement, nothing else. It does not, and the applications will not come under the pleadings.
Yes, show me where you are basing that submission from. And where is the schedule? Schedule what?
Lordship, that's an appendix 1, your lordship, which lays down the format of the statement of truth.
Yes.
At the end, your lordship.
Doesn't say suit, it says a commercial dispute.
Lordship.
My lord, 15.1 says verification of pleadings in a commercial dispute. My lord, order 6, rule 1 defines what is pleading. Pleading shall mean plain or written statement. Even in a commercial dispute, only a plain or written statement has to be verified by a statement of truth. Nothing else, my lord.
CPC ka dao, CPC ka dao. Yes, very well. Yes, now to the dispute, please.
Yes, my lord, the agreement dated 9th April 2021 for supply of potatoes. I am the supplier, the respondent has to purchase it. My lord, from April 21 to November 21, my lord, every month, the respondent had to lift an amount between 200 metric tons and 250 metric tons from me.
No,
I-
you are the supplier.
I'm the supplier.
And what will the respondent do?
He will lift an amount of potatoes from me, which I will have to procure from him beforehand. That amount was to be between 200 and 250 metric tons per month.
Yes.
My lord, he failed to do so. There was a clause which says that if there was any shortage in one previous month, on the next month, it could be made up. My lord, there were emails between us by which we said that.
So what is it? Unpaid dues?
No, my lord, damages because we procured the potatoes, we had to enter into
You procured it from the open market.
open market farmers, and they did not, according to the contract, my lord, they had to, every month, they had to lift a specific amount. They did not lift it, so we suffered damages because of the goods we had already purchased from the market.
No, that is the cost.
Yes.
What about the potatoes remained in order?
No, my lord.
You're saying damages, that's why.
Yes, my lord, we did not actually take it. We did not actually get the supply, but we had to pay for the amount that we,
Very well. What is the amount claimed?
3 crores 33 lakhs 7,422.
Yes, your 21 and all that. Please first the arbitration clause.
Arbitration clause, it has page 17. It says that in case of any difference or dispute arising between the parties herein or account of any of the terms and conditions contained therein, such difference or
Very
dispute.
well. First page of this agreement. Purchase agreement.
Yes, my lord, at page 13.
You are Apricot Foods.
No, my lord, we are SK International.
Who's Apricot Foods?
Lordship,
Then why are you buying potatoes?
Lordship, the business of apricot food is
Very well. Yes, you're 21.
21 is at page 44, my lord. 21 is at page 44. My lord,
44.
Yes, my lord. Dated 12th May 2023. We had suggested the name of one learned advocate. My lord, they have not agreed to the same.
Where have you invoked the arbitration clause?
My lord, page 45, last paragraph, as per clause 13 of the said agreement, it was expressly agreed. My lord.
What is the date of this? 12th May.
12th May 2023.
Have they replied or not?
No, my lord.
Yes, what do you have to say?
Lordship, any person may be appointed.
The dispute between the parties relates to a purchase agreement, capitals, dated 9th April 2021, executed between the petitioner and the respondent, whereby the petitioner was to supply potatoes to the respondent, and the respondent, in turn, was to lift a certain quantity of potatoes -200-250 MT per month from the petitioner. Stop. The respondent, according to the petitioner, the respondent, next paragraph, the respondent failed to lift the agreed quantity of potatoes, and the petitioner consequently suffered damages. Stop. The petitioner claims approximately rupees 3.33 crores on account of the cost of procuring the potatoes from the open market and the related and the consequential loss on account of the respondent, on account of the petitioner being unable to supply the agreed quantity to the respondent. Stop. Next. The petitioner invoked the arbitration clause, comma, which is clause 13 of the agreement, capital A, comma, on 12th May 2023 and nominated its arbitrator. Stop. The respondent did not reply to the said notice. Stop. Next. The dispute is directly relatable to the agreement, to the purchase agreement, to the arbitration agreement dated 9th April 2021. And the parties admit that there is, and the respondent admits that there is an existing dispute between the parties. Stop. This is a fit case, therefore, under section 11 within brackets 6, under section 11 within brackets 5 and 6 of the 1996 Act. Stop. Next, AP 617 of 2023 is accordingly allowed and disposed of by appointing blank with paragraph of the to be ordered to be communicated by 22nd April, 22nd September. No, after paragraph. The technical point raised on behalf of the respondent of the application not containing the required verification under Order 6, Roman, Rule 15-A, capital A, of the Code of Civil Procedure, comma, as amended by the Commercial Courts Act, comma, 2015, is not relevant since the amendment relates to verification of pleadings in a commercial dispute, and Order 6, Rule 1 defines pleading to only mean the plaint or written statement. Order 6, Rule 1 of the CPC. To only mean the plaint or written statement. ঠিক করে শোনো।
Grateful. Grateful. Lordship.
Next.
Item number 6, Rahul Enterprises.
My lord,
Could
this is
I-
my application under.
Just
section
1 minute,
1.
please.
Could I appear for the respondent in this matter?
My
11.
lord, this is the matter where, my lord, the petitioner was appointed by the respondent for running its factory and manufacturing jute bags for the
Yes, yes.
respondent, my lord, and the termination by them was in 2016. So, my lord, there was an issue of limitation, my lord, which I had to explain. For the
Yes, limitation then, 2016, right.
yes, ma'am. See,
Mr. Kormakar, you can respond to what
I have a
Ms.
few more submissions to
Kormakar-
make, my lord, if I could, before to
Yes,
supplement
yes,
my
yes.
arguments yesterday. Firstly, ma'am, I would like to place the arbitration agreement, which is contained, which is at page 27, clause 12.
Page 27.
Yes, ma'am. Clause 12, governing law and dispute resolution. 12.1, any and all claims arising directly or indirectly from the relationship between the parties, such dispute, difference, or claim hereafter referred to as dispute, under this arrangement shall in the first instance be resolved amicably by representatives of the contractor and the company. So, my lord, under this clause, I'm saying, my lord, that we had sat with them and it was mutual negotiations were going on between the petitioner and the respondent. The respondent has also written letters to us in 2018. So, my lord, the delay is from 2016.
Written letters to?
Us, the petitioner, my lord, saying that, no, we are claiming 5.47 crores and they are saying only 41 lakhs is payable by them. And there are letters to the effect saying, from them saying that only 41 lakhs is payable by them in the year 2018. So, my lord, in 2016, the contract was terminated. In 2018, we had written to them in 2016. My lord, I've prepared a short list of dates, my lord, on the point of limitation, my lord, if I could hand that up.
Very well. And one for Mr. Kormakar, please.
Yes, ma'am. Well, the termination was in January 2016. And
Yes.
thereafter, my lord, we write to them on 22nd June 2016 for release of our dues. They replied to us on 4th October 2018, stating that they're liable to pay only 41 lakhs and that the petitioner has violated the agreement and that we are supposed to pay 1.27 crores. Thereafter, there is another communication by them on 27th November 2018 saying that they're liable to pay only 41 lakhs. Thereafter, my lord, we had invoked the IBC Section 9. We had sent a demand notice under Section 9 under the IBC, my lord, and thereafter we had filed a petition under Section 9 before the National Company Law Tribunal, which was dismissed for default on 4th May 2022. Thereafter, my lord, I'm saying the period between 15th March 2020 to 28th February 2022 will be excluded.
That's because of 14, section 14,
COVID, which, my lord,
the COVID, yes.
yes, because the petition there was not
That's right,
admitted.
yes.
It was dismissed for default.
Yes.
And thereafter, my lord, there is a meeting in 2023 where they have sat with us with regard to the dues, and they have made payments to us in May and June 2023. And my lord, thereafter we send another demand notice on 10th of June, and finally the Section 21 notice on 5th of August 2023, my lord.
Yes.
So the discussions that were going on between us were mutual in nature, and hence the cause of action that had accrued by the termination of the contract, my lord, is of a continuous nature.
So you're on the breaking point.
Breaking point, yes, my lord, and my lord had asked me to look at BNT
Yeah.
AG, my lord. There also, my lord, the communications were one-sided. The respondent had replied to the petitioner saying that the case there was regarding invocation of bank guarantee, which was in 2016, and then the respondent had replied to the petitioner saying that they are not going to look into it thereafter, and there are no further communications from the respondent's side.
It was
to
a 4.5-year delay.
Yes, there was a delay beyond 3 years. So
Yes.
in our case, my lord, there are communications going on.
No,
and
sorry, 4.5 was not.
not
till.
till.
Not till.
And even there, this was over 3 years in BNT AG, my lord. And my submission is that, my lord, the communications were going on, and they have sat with us. They've made payments. Therefore, my lord, the cause of action continues, and there are judgments to the effect saying that negotiations, if they are going on between parties to settle the dispute, my lord, then limitation shall not be applicable and shall be extended.
No, you're relying on Geo Miller.
Geo Miller, and there are a few other judgments, my lord, of this High Court and Supreme Court also, my lord. If my lord wants, I can hand up the judgments.
Let me hear first, Mr. Kormukar. Yes.
But first of all, Milord, the issues of negotiation and whatever the transactions in correspondence were, Milord, as indicated in the list of date, Milord, none of them I find, Milord, I could find, Milord, from the annexures. Milord, none of them have been annexed. Milord, my next submission with respect to, Milord, the negotiation process. Milord, negotiation, only negotiation, Milord, does not, Milord, create any right
So, Mr. Kormukar, you're taking the point of delay.
of delay.
Delay.
Lord, does not create a right under Section 18 of the Limitation Act. If one has to come within the ambit of Section 18 of the Limitation Act, Lord, there has to be a written acknowledgement. Here in this case, the only, Lord, claim of the petitioner, that is it with respect to, Lord, payment in the midst with which they say they have appropriated with their previous dues.
No, you first paid when?
Lord, the first payment was made in 2023. And that is also on some different account.
Yes.
For that, Lord, I can explain in affidavit, Lord, but verbally I cannot. Lord, kindly comes to page 23 once. First, I'm sorry, page 20.
Yes.
Cost of contractors' personnel. The contractor shall be solely responsible for payment of all wages, salaries, costs, and expenses of.
Mr. Kormukar, I'm not going into the dispute.
Yes, Lord,
Then-
why I'm placing this with your lordship is, there are two segments of payments. One is with respect to the goods sold and delivered. They will manufacture a product. I will buy that. I'll pay them, Lord, the money. That will include all the costing, whatever it is. And the other aspect is with respect to these wages and the, Lord, officials or personnel who have been appointed or engaged by the petitioner, their payment. Now, Lord, your lordship knows, Lord, in the other matter, this NGMC same. This is of
What other
Katihar
matter?
unit. The other matter, Lord, where Mr. Bose is arguing the same.
Don't say other matter, Mr. It's very incestuous.
So, Sushil Kumar Thad.
Yes.
Sushil Kumar Thad. Lord, in that matter,
No, Mr. Kormukar, no. if your learned friend is not part of the other matter, you cannot make any comparisons.
No, I'm not comparing.
No,
Lord, the
no,
issue
just make
is-
a general submissions in law.
Lord, the
please.
issue is that
If she had also been part of that matter, you can, you
I'm
could
not,
have,
Lord,
yes.
I'm only to indicate the facts I'm placing. Lord, the issue is here NGMC is closing down.
Yes,
Now, Lord, there is a direction for closure of all units and whatever the goods are there, it has to be sold out. Now, Lord, similarly, Katihar unit is also one of the part of that. Lord, in the process of this selling out, we found that, Lord, this wages and, Lord, salaries of the workers were never paid by, Lord, the contractor, that is the petitioner, which they were bound to under this contract. Now, Lord, because of the non-payment,
Mr. Kormukar, there is a dispute.
Lord, the
The
dispute,
court will not, the referral court will not go into whether what the petitioner has,
But,
maybe the petitioner has done something which is totally contrary to the contract.
Grants me
Let the
one,
arbitrator decide that.
grants me 1 minute's time, I'll try and explain. Lord, there are two parts. So, Lord, we found that until and unless we make the payments to the the workers, Lord, we cannot sell the units in the Katihar, whatever it is there. That became the problem. So, Lord, we caught hold of them. The negotiation was, yes, we'll pay your, Lord, workers. This payment is on account of the payment of workers.
Very well, let the
Not on
arbitrator decide
account
that.
of, not on account of,
Let the
Lord,
arbitrator decide that, what the payment was on account of,
Lord,
and
but I
maybe you will
was-
succeed in the arbitration.
Lord, I agree on that. But
Yes.
what was bothering me is, Lord, the payment of arbitration, the payment that they can ask in the arbitration is only restricted to 7.1, not beyond that.
7.1
That is
rupees.
page 22 of the petition. Clause 2 to 7.1, not beyond that. So, Lord, if the payment which I have made to them is not in 7.1, then perhaps, Lord, the limitation comes into.
Yes, 7.1 is the arbitration clause,
7.1 is the payment clause.
payment clause.
If they have to appropriate the payment that I have made, that has to be done in terms of 7.1 only. If not, then limitation
No, no,
comes into.
Mr. Kormukar, clause 12 says any and all claims directly or indirectly
That
from the
is-
relation,
that-
extremely wide.
But that is exactly why I placed, Lord, 6.3 and 7.1.
No, no, no.
6.3 is no
Mr.
claim at all.
Kormukar, the arbitration clause is
Lord, in
wide,
that case, may
wide
I-
enough.
In that case, Lord, may I pray this with your lordship? Kindly keeps this limitation point open, Lord, so it can.
Naturally,
Lord, if my learned friend, Lord, agrees, Lord, I can suggest a name, Lord, subject.
not at
to-
all. It's a prerogative of the court.
Great.
You will not suggest any name.
Great.
Yes, just show me that I have to deal with that. The TNAG, the Justice Pardiwala's judgment. Justice Pardiwala, yes.
Paragraph 9 contains the sequence of events. And my lord, we'll see at page 3 of the judgment. 16th February 2016 is the date on which there was a wrongful imposition.
No, paragraph 9 is submissions on behalf.
Yes. so,
Ms. Bormon Roy, you have to give your Mr. Kormukar a copy.
I don't. I have.
Very well, Mr.
I'll
Kormukar, you
find it.
wait. I will give you my copy. Just tell me the paragraphs, please.
Yes,
Paragraph 9 is
the-
submissions.
The third page, page 3, the page after that. My lord
Yes.
kindly turns the page. So this contains a sequence of events in this particular case, my lord. So 16 February 2016 was a wrongful imposition of liquidated damages. Thereafter, my lord, the respondent had replied on 22nd September 2017, saying that they would not reconsider the request. And thereafter, my lord, there are only communications on the petitioner's side asking for, saying that there are negotiations going on. So in our case, I'm trying to distinguish this, our case from this case is that on the basis that there were communications from both sides. And my lord,
1 minute, Mr. Gupta. Outside the court and yawn. Or at least cover your mouth. Yes,
so
yes.
And my lord, in this case also deals with Geo Miller at paragraph 43 to 45 and paragraph 44. My lord, if I may just place. At page 15, the aforesaid observations make it very clear that what is important for the court is to find out what was the breaking point at which any reasonable party would have abandoned efforts at arriving at a settlement and contemplated referral to the dispute for
You're looking
arbitration.
at paragraph 28.
Paragraph
of-
44.
No, paragraph 44.
44 of
Well,
BNTAG.
Yes.
which, they are,
Yes, yes, yes.
yes. So paragraph 44 says that at what will be the breaking point? And hence, my lord, and they say that when the parties have abandoned efforts, here, my lord, there is continuous negotiations going on by both sides, and they have written to us. There are IBC proceedings. They have participated in the IBC proceedings, my lord, and thereafter they've made payments to us in 2023. On that account, my lord, I'm just praying that the cause of action continues and is not, and the claims raised by the petitioner are not ex facie time barred, my lord. They waive their right by writing to us and by participating in the IBC.
And paragraph
proceedings.
45 of NOTEL.
Paragraph 47 deals with not.
No. Paragraph 45 of NOTEL, you're relying on, you will rely on.
I haven't relied on Nautilmal because in Nautilmal, they had not taken any action for after the rejection of the claim, which is quoted in this judgment at paragraph 58. Yes, paragraph 48 of Nautilmal. At page 18, paragraph 58 of BNTAG quotes paragraph 48
And
of
give me the
Nautilmal.
citation of Geo Miller, please.
Yes. Geo Miller is at is 2020-14 SEC 643. I'm relying on paragraphs 28 and 29.
Very well. Yes. This is an application for appointment of arbitrator under section 11 of the 1996 Act. Stop. The dispute relates to a job work contract, quotation marks, job work act kotha hobe, page 13. Job work contract dated 27th October 2014 between the respondent and the petitioner. Stop. By the said contract, comma, the petitioner, within brackets, described as the contractor, close brackets, was to manufacture and run one of the factories of the respondent. Stop. Is that correct or not?
Yes.
Run one of the factories of the respondent. Stop. The contract contains an arbitration clause in clause 12 of the contract. Stop. Next, the dispute, as also the grievance of the petitioner, is that the respondent terminated the contract on 16th January 2016. Is that correct or not?
Yes.
16th January 2016, 16 January 2016. And thereafter paid, but thereafter paid some amount of the petitioner's dues on account of the job done by the petitioner in terms of the contract. Stop. The petitioner now claims approximately rupees 5.47 crores, correct? 5.47 crores on account of its unpaid dues. Stop. The parties, the petitioner also invoked the provisions of the IBC, of the Insolvency and Bankruptcy Code, 2016, against the respondent in 2019, which was, however, subsequently dismissed for default. Stop. The petitioner also, the petitioner thereafter invoked the arbitration clause by a notice under section 21 of the Act on 5th August 2023, Stop. The respondent replied to the notice on 14 September
No, madam,
2023.
there is a reply prior to that, but it is undated.
Very well. A reply to this notice by an undated letter raising counterclaims against the petitioner, but agreeing to, but stating that the petitioner is not disinclined to proceed to arbitration. Stop. Next, the dispute between the parties hence relates to the unpaid dues of the petitioner, which is found to be relatable to the arbitration agreement dated 27th October 2014. Stop. That should have been the first date in your list of dates. Stop. Next. Although the court is inclined to allow the application for appointment of arbitrator, comma, a preliminary objection raised on behalf of the respondent must also be answered. Stop. Next, learned counsel appearing for the respondent submits that the claims, that the petitioner's claims, adjoint petitioner apostrophe, petitioner's claims are barred under the laws of limitation. Since the contract is of 2016 and the invocation of the arbitration agreement is of August 2023. 15th August 2023. 5th August 2023. Stop. Next. The correspondence exchange between the parties, comma, as pointed out by learned counsel appearing for the petitioner, comma, indicates, fits into the breaking point, quotation marks, breaking point decision of the Supreme Court in Geo Miller. Give me the citation, please. The cause title.
Geo Miller and Company Private Limited versus Chairman Rajasthan Vidyut Utpadan Nigam Limited.
देखें 2020 14 SCC 643, where the Supreme Court held, where the court held in paragraphs 28 and 29 of the report, capital R, that it is important for the court to find out whether whether a reasonable party would have abandoned efforts at arriving at a settlement and contemplated referring the dispute to arbitration. Stop. This was also taken note of in the recent Supreme Court decision in B and TAG versus Ministry of Defense, 2023 SCC Online SC 657. Stop. The later decision, however, frowned on continuing correspondence seeking to beat beat limitation. Stop. The facts in B and TAG were, however, different, and there was a delay of over 3 years in that case, in the facts of that, in that case. Stop. Next, the একই paragraph করে দাও. The sequence of events in the present case indicates that although the contract was terminated on 16th January 2016, comma, the petitioner wrote several times to the respondent for release of its dues and also initiated corporate insolvency resolution process against the respondent, comma, albeit, albeit, albeit unsuccessfully. Stop. The respondent also wrote several letters to the petitioner from 4th October 2018 on 4th October 2018 and 27th November 2018, besides making payments to the petitioner in May-June 2023. Stop. The respondent also responded to the petitioner's notice invoking the arbitration clause. Stop. The petitioner is also saved by the orders of the Supreme Court, which lasted till 28th February 2022, extending all periods of limitation under the special and general laws by reason of the pandemic. Stop. The chain of correspondence, the chain of correspondence, CHAIN, the chain of correspondence shows that the parties remained in contact, comma, responded to each other, and all efforts at settlement and all efforts at amicable resolution of the dispute failed after considerable efforts on the part of the petitioner. Stop. Next, the question of limitation is hence answered in favor of the petitioner. Stop. The petitioner next, the court must also rely on the decision in Watt versus Nautel. Give me the cause title and the citation, please. Where the Supreme Court was also of the view that the referral court must come to a clear decision on the claims being ex facie barred by limitation in refusing to allow an application under Section 11 of the Act. Stop.
Bharat Sanchar Nigam Limited versus Nortel Networks India Private Limited.
What is the citation?
Reported in 2021, 5 SEC 738.
And just check whether this is in paragraph 45 of the decision. Yes. Next, AP 649 of 2023 is accordingly allowed and disposed of by appointing blank to act as the arbitrator, paragraph to be communicated by 22nd September 2023. Ms. Borman Roy, please give the citation and the cause title.
Item number 7, the principal chief engineer Metro Railway.
36.
My lord, this is my application praying for leave to deposit the.
I can't understand. Microphone, please.
This is my application praying for leave to deposit the demand draft amounting to rupees 48 lakhs.
Don't you know how to use a microphone, Ms. Banerjee? I'm telling you, I can't hear you. Just pull it across.
Well, this is my application praying for leave to deposit the demand draft amounting to rupees 48,82,092. Well, the section 36 application was disposed of by your lordship on 4th July 2023 by directing the petitioner to deposit it within 4
Where is
weeks.
the order?
Well, at page 7.
You are beyond the time limit.
Yes. Madam. Page 7 is the order. Your lordship granted 4 weeks time. The demand draft was prepared on 14th August, my lord.
When did the 4 weeks expire?
2nd October, 2nd August. Well, page 9 is the copy of the demand draft.
2nd August.
Yes.
Yes, what do you have to say, Mr. Chakraborty?
My lord, firstly, my lord, this application has been filed in connection with the disposed of petition. That
Yes.
has already been disposed of, and my lord, the ground for delay has been mentioned in my lord, paragraph 3 of the application, which according to my lord, your lordship may consider that whether that is a sufficient ground or not. And secondly, my lord, the award says that after 45 days, if they don't pay, then they have to give 12% interest. Simply
After 45 days
Yes.
of the date of the award.
Yes, my lord. So, my lord, since
What
they
is
have
the date of
already
the award?
failed, that is 10th August 2022, my lord.
Date of the award.
Yes.
And 45 days would be
My lord,
2022 or 2023.
25th of September 2022.
10th August, what is the date of the award? 22. And 45 days would be?
Lord, 45 days would be, my lord, 25th of September 2022.
2022.
So, my lord, exactly 1 year, my lord, has.
And 12% interest from after 45 days.
Yes, my lord.
And they have filed the application for stay when?
This application was filed earlier. my lord. It was
No, the original in which the order was passed.
My lord, in 22.
in the year 23, my lord, not 20.
No, April 22.
They have filed the application, my lord, on December 22. Now, since they have defaulted, my lord, if your lordship finds the reason to be, my lord, sufficient, my lord, kindly direct them to deposit the interest amount. Which
Yes,
is,
what is the calculation sheet?
that is
Show me, please.
5,85,000 for 1 year, my lord. 12% for 1 year. Exactly, it comes to 25th of September, it will be 1 year.
What is, they were supposed to deposit 48 lakhs.
48 lakhs.
48 lakhs. How much do you want them to deposit?
Now, my lord, 54 lakh 67,943. Interest amount is 5 lakh 85,851. Which is the accumulated interest at the rate of 12% till 25th of September 2020 for 1 year. And, my lord, if a part of that can be, my lord, withdrawn.
No. That will come later.
My lord, the demand draft is ready, my lord. Let us deposit this amount. We have prepared the demand draft on 14th August, my lord.
Then, my lord, additionally 5 lakh 85,851 by way of another demand that they can deposit, my lord, if your lordship so has.
Yes. This is an application filed by the award debtor. Metro Railway, comma, in a disposed of arbitration petition. Stop. Being AP 819 of 2022. Stop. Next. AP 819 of 2022 was disposed of by an order dated 4th July 2023. Now, AP 819 of 2022 was filed by the award debtor for stay of an award dated 10th August 2022. Stop. The said AP was disposed of by an order dated 4th July 2023, directing the award debtor to pay rupees 48,82,092 to the registrar, original site within 4 weeks from today. from the date of the order. Stop. So the award was not, is still free for execution
Yes, madam. We are in the process of filing.
Yes. from the date of the order. Stop. Next, the petitioner, comma, the award debtor, comma, through learned counsel, comma, says that the award debtor was unable to comply with the direction passed by the court, since the award debtor could not prepare the demand draft as required within the stipulated time for reasons beyond the control of the award debtor. Stop. Next, learned counsel appearing for the award holder objects to the reason given for the delay and refers to the impugned award, which directed the award debtor to pay interest on the awarded amount at 12% per annum after 45 days of the award, which comes to 25th September 2022. Stop. Council submits that if this rate of interest is to be taken into account, comma, the award debtor would have to pay rupees 54,67,943 with including an interest including the interest component of rupees 5,81,851. Is that correct or not?
585,851.
5,85,851. Stop. Next. The after hearing learned counsel, comma, this court is of the view that the petitioner was, now after hearing learned counsel, comma, it appears that the petitioner was to pay the amount as directed by the order dated 4th July 2023 by 2nd August 2023. Stop. The present application was filed on 16th August 2023. Stop. Since the demand draft is ready for furnishing, comma, the court is not inclined to go into the question of enhanced interest. Stop. Any such questions would be the subject matter of the Section 34 application. Stop. The petitioner / award debtor will, however, no, stop. The award holder / respondent will, however, be at liberty to withdraw 50% of rupees 48,82,092 within 7 days from the date on which the petitioner / award debtor furnishes the bank guarantee, furnishes the demand draft. Stop. The award debtor shall furnish the demand draft to the registrar by 12 p.m. tomorrow, i.e. 20th September 2023. Stop. Next, GA2 of 2023 is accordingly allowed and disposed of in terms of the above.
Deeply approved.
Actor line लिखे दो तो. The award holder shall furnish a bank guarantee of an equivalent amount, after withdrawing 50% of the amount as directed. Stop. Next.
There be a time limit for filing the bank guarantee?
Yes, yes. The bank guarantee shall be filed within on the same date as the amount is withdrawn.
So within 7 days, my lord, it will be very difficult, but if your lordship kindly gives.
Well,
2 weeks,
14 days, you
weeks.
can 7 days column, not a 14 days column.
Deeply appreciate.
Item number 8, Radha Raman Mondol.
May it please your lordship, my lord, this is my second application, the section 29A.
Microphone, please.
This is my second application under section 29A.
Where is
of
your
the-
respondent?
But
Why are you sitting down?
Yes,
You're the respondent.
yes, ma'am.
Are you opposing?
No, 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 not at all.
No. You're a respondent in the arbitration as well?
Yes.
Yes, not sure.
Yes, yes, yes. But
Yes,
and arguments of the respondent is going on. And my lord, the witness action has been completed. Why it took so much of time is because, my lord, there were 12 witnesses of the claimant and 1 witness of the respondent, and there were exhibits in excess of 18 numbers. Both parties combined. And also, my lord, all the witnesses, they had to be interpreter to, my lord, because all of them had answered in the vernacular languages, my lord, the depositions. That is why, my lord, it took so
when
much
did the arbitration start?
my lord, the order by which the arbitrator was appointed, my lord, is
That's
10th
not
of-
relevant for 29A.
that is when the arbitration had started, because my lord,
What is the date?
10th of July 2019.
Yes,
In an appeal from a section 9 order, because there was no section
very
21.
well. Are you within the timelines of 29A?
We are within the timelines.
You are.
My lord, there was a 29A exclusion by the Honorable Supreme Court, my lord, 15th of March till 28th of February 2022. The pleadings were completed, my lord, on 16th November 2021. And my lord, your lordship had extended the mandate till 17th of my lord, October 2023. That has been recorded. My lord will kindly have a look at the minutes of the 48th sitting at page 248, which is the second volume.
No, where is the order? Where is my order?
Yes, page 24. 21st of June 2023.
So 4 months,
My lord, page 25, my lord will see.
yes,
the
yes. So
penalty.
4 months from 21st June would be,
My lord, 4 months from the communication, but we had taken it as 4 months from the date of the order, 17th of October 2023. So we are within the time, my lord, and we have.
so then why do you want an extension again? We are in September.
We are in September, my lord, because there are several documents and, my lord, 12 witnesses of the claimant whose depositions are being placed by the respondent.
No, no. So
Claimant's
which
arguments have been
witness, which witness is going on?
No. Witness action complete, claimant's arguments complete. The
Yes.
respondent is arguing at this present. And my lord, since there are arbitration consists of, my lord, voluminous documents. So, my lord, the argument is taking a lot of time. The arbitrator has fixed 8 dates, but the time to pass the award, that would be, my lord, difficult. That is why, my lord, we would possibly complete our arguments within the dates fixed. But to pass the award, my lord, that is a short extension, if your lordship kindly.
Short, you've asked for 6 months.
I've asked for 6 months, but till maybe, my lord, mid of January, my lord, if it so commences to your lordship. Considering there
Middle
are
of January is how much?
my lord, this would be, my lord, from
4 months.
21st of October. My lord, it is still the 17th of October, so that would be 3 months. And considering there's a long vacation in the meantime, my lord, that is why, my lord, if your lordship kindly.
Long vacation, so?
If your lordship kindly considers.
Absolutely not. Long vacation, you work. Yes, this is a second extension. This is second application for extension of the arbitrator's mandate, of the learned arbitrator's mandate under section 29A of the 1996 Act. Stop. The court had extended the mandate, had earlier extended the mandate by an order dated 21st June 2023 for a period of 4 months. Stop. The 4 months expires on 17th October 2023. Stop. Next, learned counsel appearing for the petitioner / claimant in the arbitration, comma, submits that the arbitration, that the award may not be made within the extended period of time since there are several witnesses who have been examined in the proceeding. Stop. Counsel, however, submits that the witness action is complete and the parties are presently making their arguments. Stop. Next. AP 673 of 20, after hearing learned counsel, comma, and reiterating the fact that the reference started from 10th July 2019, comma, the mandate of the learned arbitrator is extended, comma, hopefully for a final term, comma, for 3 months from 17th October 2023. Stop. Allowed and disposed of बोलेंगे?
Item number 9, Say Equipment Finance versus Mr. Sheikh Rashidul Islam.
No, this is my section 9 application. My lord, this application, my lord, is appearing today for the first time. Needs to be withdrawn and filed because there is an assignment agreement which has taken place. So my lord, the
Taken
party.
place after filing of the
No,
application.
my lord, prior to it, my lord. So my lord, the party who in favor of whom it has been assigned has to be made a party in the section 9 also.
So why did you not make him a
My
party?
lord, he has not been made a party, I find. So my lord, I wish to withdraw and file afresh, my lord. It has been filed, my lord, and today it's appearing for the first time, my lord. Because in the section 21 notice.
Learned counsel appearing for the petitioner seeks to withdraw the application on the ground that an assignment agreement which was executed between the parties does not find place in the application. Stop. Next, considering the fact that the application was filed on 10th August 2023 and the assignment agreement is of
My lord, 27th of March 2019, my lord.
27th March 2019, comma, AP 543 of 2023 is allowed to be withdrawn and is dismissed as withdrawn upon costs to be paid by the petitioner of blank to blank within 7 days from date.
And my lord, liberty to file afresh, maybe.
Liberty to file afresh.
Great.
Item number 10, Sheikh Mujahidul Islam.
Appealing for the petitioner, lordship, on the last, for the respondent. On the last occasion, lordship, there was an order passed by your lordship directing us to file the typed copy of the agreement. Which I'm in some difficulty, lordship. There's an innocuous prayer if they can supply a copy of the agreement, because the agreement which is there presently, the typist also cannot type it.
Yes.
Direction only for.
So why did you not ask for it on the last day?
Because
last
I
occasion?
thought that it will be typed, but the typist also could not, we do not have a better copy also. If
This agreement was served on the agreement was
Very
served.
well, give another copy, please. How much time do you want?
Week's time, my lord, because this the agreement is a illegible copy. I have to make it.
You also can't make out the
But-
agreement.
My lord, that has to be typed and we will supply.
So you will type and then figure out the terms.
No, my lord, not that.
Yes,
1 week's time, my lord, be given.
learned counsel appearing for the petitioner renews his prayer for time to produce a legible copy of the arbitration agreement. Stop. Counsel submits that counsel requests that the respondent may give a copy, may furnish a copy of the agreement to the petitioner. Stop. Next, list this matter on 4th October 2023. Stop. The respondent will serve a copy of the agreement, arbitration agreement on the petitioner by
My lord, by 30th September, my lord.
by 27 September 2023.
Highly obliged.
Item number 11, Stray Equipment Financial.
My lord, this is my application for substitution of an arbitrator, my lord.
I
Under
can't
section-
understand what.
My lord, this is my application for substitution of an arbitrator under section 14, read with 15, my lord, of the arbitration.
Where's your other side?
My lord, Mr. Ritoban Sarkar was appearing, my lord. He's not appearing today.
Yes, you want termination.
No, my lord, the erstwhile arbitrator had reclused herself, my lord. So I want a substitute arbitrator to be appointed.
What are you saying? Recluse?
Recluse.
Why? She's a recluse.
Recuse, my sir. I recuse herself.
Yes. Show me the name of the arbitrator, please. Don't have to announce it. Give me a page, please.
Yes, ma'am. Page number 63, ma'am.
63.
Yes, ma'am.
But many arbitration sittings have been held already. Then why is she recusing?
Madam, 2 arbitration sittings had been held, my lord. Thereafter, on the 3rd sitting, she recused herself.
Where is the letter?
My lord, page 67.
When did you file the application?
Madam, in June, my lord.
How many sittings held?
My lord, 2 sittings, ma'am. Madam, first sitting held on,
You're the claimant.
yes, ma'am.
How much is the, what is the claim?
19 lakhs, madam, approx.
Approx.
Madam, 19, and it's 19 lakh 7,428, madam.
Yes, this is an application
Under section 14, my lord.
for. Where is your prayer?
Madam, page 8. Madam. Page 8 of the application, madam.
This is an application for substitution of the erstwhile arbitrator who was appointed by the court.
No, my lord. Appointed by the client, madam, claimant, my lord, under section 21.
Appointed by the
Claimant, my lord. Petitioner.
who was appointed by the parties. Stop. Learned counsel appearing next. Learned counsel appearing for the petitioner refers to places a letter dated 25th April 2023, where the learned arbitrator has sought to retire from the proceedings on the ground of personal difficulties. Stop. The records also show that 2 arbitration sittings were held before the arbitrator before the arbitrator retired from the proceedings. Stop. Next, the respondent was represented on the last 2 occasions. On the last 4 occasions. Stop. However, no one appears today on behalf of the respondent. Stop. Should be an application under 15, not 14.
My lord, there is a judgment of this honorable tribunal, honorable court, my lord, under section 14, read with 15, my lord.
Yes. AP 377 of 2023 is accordingly allowed and disposed of by appointing blank to act as the arbitrator in place and stead of the erstwhile arbitrator. Stop. The newly appointed, the arbitrator appointed, comma, will resume the proceedings from the stage at which the earlier proceedings were left incomplete. Stop. This order shall be communicated on the learned arbitrator within 22nd September 2023, along with all relevant details of the contact person of the petitioner. Stop.
Much obliged. Gentlemen.
Next.
Item number 12, Acumen J Marketing Private Limited.
My application, my lord, for setting aside of an award under section.
This is the first time, Mr. Dutt.
This is final hearing, but before your lordship, my lord, it's for the-
Mr. Dutt, microphone, please. Order gulo dao to.
এখানে before your
And who was
lordship-
appearing for the respondent? No one.
Mr. Rajesh Dotto is appearing for the respondent, madam.
paper books আছে।
Yes.
My lord, before your lordship gets troubled with the papers, my lord, just
Yes.
give me background.
Yes.
My lord, this pertains to, my lord, a tenancy agreement where, my lord, the landlord says it's a license. I say it's a tenancy, and the arbitrator says it's a lease. It's a lease. Now, my lord, this pertains to, my lord, an electronic shop, my lord, which is being operated.
You're the tenant.
I am the tenant, licensee, or the arbitrator has held I am a lessee, my lord. So therefore, my lord, I'll proceed on the basis that I am a lessee, but it's wrong. My lord, this is, my lord, a shop, my lord, in electronic mall, my lord, we call it e-mall, my lord. We are, my lord, distributors of Sony.
Distributors of
Sony.
Sony. Oh,
Sony.
Sony, yes.
And Samsung. Now, my lord, we have been operating this electronic shop and carrying on business from 2010. The modern manner of relationship is, my lord, there were 11 months agreement. From 2010, every 11 months, a fresh agreement was being executed between the parties. This property belongs to a company, say X. The maintenance charges, my lord, maintenance is provided by company B and bills are raised. And company C is a company which provides the infrastructure and other things. Facility agreement, they are called. So I pay rent in three parts. One is towards rent, one is towards facility, and one is towards maintenance.
And that is the way the agreement has been designed.
There are three agreements, and all three contain an arbitration clause. Three, because the entities are also three. There are three separate companies.
And those are your papers.
Yes. My papers, but I'll only trouble your lordship with volume 11. No. Volume
So you
11.
don't want to file an inconvenience volume.
If your lordship so desires, my lord, it would be very helpful because I have found most of the things are not very relevant. Now, my lord, the facts are this, my lord. In August 2017, in July 2017, the last of my agreements were coming to an end. Before expiry, they gave me a notice that within the next 20 days, your agreement is expiring. So you better come and negotiate. On the
Yes.
penultimate day, my lord, I write to him saying that, well, there is a renewal clause in a license agreement. So therefore, please renew it.
Mr. Dutt, you probably know better than the court that 34 will not attract all these facts, at least at the beginning.
Anyway, my lord, but patent illegality, my lord, where I come in is, my lord, what I'm trying to justify. That's what, my lord. So, my lord, just give me 2 minutes, my lord,
Yes,
because
yes.
so, my lord, in August, my lord, when my license expires or lease expires, whatever, my lord, I
Yes.
continue with my business. August, September, October, I pay rent, I pay maintenance, I pay facility. And it has been accepted. Thereafter, my lord, and rent receipts were also issued acknowledging receipt. Thereafter, my lord, another notice was issued, which does not relate to the previous notice of termination, saying that, look, your license has come to an end in July. Therefore, please vacate. And that is where, my lord, the arbitration clause was invoked because I did not vacate. Now,
You did not
I did not vacate. And that
vacate.
did not vacate. That's the reason why, my lord, this dispute arose. Now, before the arbitrator, my lord, there was one reference which was dealing with all the three agreements, because the claimant says, and in fact, the agreements record that they are coterminous.
So that's under a section 8, or it was you went out of court?
My lord, I went to court. It's a section 11. I'm coming to that. It's a section 11 appointment. It's a section 11 appointment. Thereafter, my lord, we took the point before the tribunal that there are three separate entities, three separate arbitration clauses, and there cannot be one reference. So you can be the one arbitrator, but there should be three separate arbitration proceedings. One would be deciding eviction, one would be deciding maintenance, and one should be deciding the facility. The arbitrator agreed to that, and there are three references. Now, out of the three references, my lord, he has decided only one. And in the process, my lord, he has already expressed his mind what would be the other two. Without
So the impugned award relates to one of the
And
references.
so far as the pending is concerned, is regarding mean profits and areas of facility charges. He's already decided mean profits because he has decided the whole mean profit, taken 1/3 of it, because there are three agreements, and said that I'm supposed to pay this amount in this award. But that's the last part.
So which reference has he decided?
He's decided the eviction one.
Eviction. And but he's in that process, he's also decided the
The mean
facility and the
profits
maintenance.
yes. That was, my lord, one of the grounds. We filed an application under 34. In that section 36, my lord, we have been paying the rent as per the award and as per the directions of this court. Now, my lord, if your lordship sees the award, lordship will find that the claimant had come. This is where, my lord, my patent illegality comes in. The claimant had come before the tribunal, saying that
You're the claimant.
no, my lord, I am the respondent.
Responding.
The claimant had gone before the tribunal claiming that I am a licensee. The arbitrator says that it has to be looked into because the question of whether you are a lessee or a licensee is derived from the nature of the agreement and how the parties have conducted themselves. Having said so, my lord, he comes to the finding that since the agreement says it's a license, therefore it's a license. Which, my lord, in my respectful submission.
That is what the claimant landlord had said.
Yes. But while deciding that, my rights under that document, my lord, he applies all the provisions of the Transfer of Property Act. 106, 111, what are my rights? That's the first point. The second point which I would like to argue before your lordship, my lord, is something which lord, I feel is not there, but this is a question of law. My lord, if
Not there as in not in the
in the
award.
petition.
Yes.
My lord, if my agreement under which I was occupying a property has come to an end in July, and I continue to remain in possession upon payment of rent for the months of August, September, and October, I can be anything but a trespasser. Because a trespasser is not required to pay rent. He is only liable to pay damages for wrongful occupation. I can be a tenant. I can be a lessee from month to month. but I cannot be a trespasser.
And that is what the arbitrator has held.
No. The point which I'm trying to raise is that if a tenancy has come or a lease from month to month has come into being for the months of August, September, and October, which is sought to be terminated by the notice in November, below these three agreements, my occupation for these 3 months are by operation of law. Because law gives me the right. I become a month. If law gives me a right and it's by operation of law, the termination of this right of mine is not governed by the arbitration clause, which Millard ended with my occupation in the month of July. Had I not paid rent, had I been a trespasser or anybody in wrongful occupation, then that arbitration clause under which I had the right to last occupy the premises on July would have governed the disputes. But since I have paid rent for the months of August, September, and October, which is admitted,
And what is the arbitrator held?
Arbitrator has gone to the very simple conclusion that even if I pay rent and the landlord accepts it without having any intention to extend the lease, then I don't get a right. But Millard, having said so, where does the question of intention come is also another point which I'll address, Your Lordship. So far as acceptance of rent for the months of August, September, and October are concerned, my learned friends' clients have gone on record to say that it was a mistake.
What was the mistake? Sorry.
The acceptance of rent, the act of acceptance of rent was a mistake. Could be. But Millard, to establish a mistake, it can be once, but it can't be thrice. That's number one. You can't commit a mistake thrice over for 3 months.
August, September, October.
Yes, 3 months. Secondly, and more importantly, is if it is a mistake, then the person who is committing the mistake has to come and say under what circumstances he issued it. That's, Millard, the basic, Millard, what should I say, notion of law. If I have committed a mistake, it's my misunderstanding for which, Millard, parties may or may not have got some right. But the person who is given evidence is not that person who commits a mistake. It's an authorized representative who comes and says, my employee has committed a mistake. So the best evidence of mistake was not before the arbitrator, but the arbitrator holds that it was an unintentional act to issue rent tips. It cannot be, Millard. Obviously, Millard, the boss cannot come and say the employee has to come and say that under these circumstances, I have been issuing bill for the last 10 years. I did not notice, I did not know that it has come to an end, and therefore I have been issuing bills. That evidence was not before the arbitrator. Second, another point, Millard, which we have argued and which the arbitrator may not have probably dealt with is, Millard, we had a counterclaim saying that we are a tenant. That point has not been expressly dealt.
So the respondent says tenant, the claimant says licensee, and the arbitrator holds lease. Yes,
Millard,
and the arbitrator says that it has to come from the intention as reflected in the document and conduct of parties.
Conduct he has not taken. That is where, Millard, I am on. He says that it has to come from that. But when he comes to the conclusion, he says, since the agreement says that he will never have any absolute right, therefore it's a license. Well, the test that is applied, Millard, I'm not saying that the conclusion that he has come in, but the test which he has applied is contrary to law.
And Mr. Dutt, how does one know that there were 3 separate references and only one was decided by
That's,
the
Millard,
impugned
would
award?
appear from the minutes.
And that the arbitrator makes clear.
Yes. And Millard, 1 is going on, the 2 are pending.
2 are pending, and the impugned award is in one, but deciding the issue in the other 2.
According to me, that it has transgressed and gone into the other reference or the disputes which is pending before the other. Yes, take on it. Oh, the arbitrator has stayed. I was not.
Sorry?
The other 2 proceedings, arbitrator has stayed on an application filed by the respondent against.
Oh,
which
I
we have
was not
come up
aware of that.
by way of 37.
I've
appeal.
heard this point somewhere.
Lordship was hearing this.
Oh,
So you have filed a 34 from that?
I have filed, my lord, 37 appeals, my lord.
37.
Yes. They filed 17, my lord, for stay of the proceedings in the other two references. In that, my lord, application, arbitrator, my lord, passes an order staying the references, against which we have come up in 237 evidence.
Very, well.
Those would be, my lord.
Very well.
primary.
Mr. Dutt, just show me the last page of the award, please.
My lord, the award starts at page 1461, volume 11. And the last page of the award is page 1488. কেন কি আছে? জজের লাস্ট পাতা দেখতে যাবেন না, যেটা দেখতে যাচ্ছি সেটা না। It starts at 1461, last page is 1488.
So your 37 is from a 17.
Yes, my lord.
So the orders, the arbitrations was what has been stayed, the two arbitrations?
Yes, because my lord, in respect of one unit, there were, my lord, 3
Yes,
agreements.
whatever. I will, when your turn comes, I will hear it. Yes, Mr. Dutt, tell me when, what do you want to do? Mr. Chaudhary, you're in this matter?
He is leading me.
Yes, Mr. Chaudhary, what is, you want to file an opposition? What do you want to do?
No, my lord, everything is done. Lordship will take it up.
Pleadings are complete. Very well. Tell me,
Because
Mr.
we
Dutt,
will rely only on the records of the arbitrator. We will not file any separate opposition.
records in 14 volumes.
Already 14 volumes are there. Everything is there before your lordship. No need of any additional.
Yes, Mr. Dutt, when?
Some
Date in 2024.
Commented. At any time, when you.
What is the date of the award? 22nd December 2021. You're within time, I hope, 2022.
No. 2021.
Tell me, sometime in the third week of October or the last week of November?
Not third week of October.
Not third week of October. So you don't want the last week of November also on the
No,
same, for the same reason?
No, November I will get ready, but not third week of October.
So tell me, 28,
But any day
29,
after
30.
November, any day when the business of the court permits.
The court opens in the fourth week. So 30th November. That is all right, Mr. Chaudhary?
Yes.
Yes, learned counsel appearing for the petitioner / award debtor. Acting Danato, award stayed?
Yes, well, award
State,
state,
when?
36 file, order though.
No, just give me the rough, I don't want to see the order.
Right, then. State award.
Ki bola? Has made his preliminary submissions. Stop. According to counsel, the award.
Stayed on 6th of May 2022.
Very well. According to counsel, the award suffers from perversity as the learned arbitrator failed to take into account certain significant facts in coming to the conclusion that the agreement between the parties is in the nature of a lease. A lease agreement. Stop. Counsel further submits that the learned arbitrator, while disposing of only one of 3 references, has nonetheless proceeded to decide issues in the 2 pending references. Stop. Next, it appears from the submission of learned counsel appearing for the respondent within brackets claimant in the arbitration, close brackets, that the other 2 references have been stayed by the arbitrator by an order dated, what is the order?
That proceedings are not before your lordship.
Very well, give me at least a year, 2022, 3. By an order passed by the arbitrator himself. Is it himself or herself?
Himself.
Himself. Stop. Next, list this matter on 30th November 2023 as prayed for. And all the records are before the court and affidavits are complete. Stop. List this matter thoroughly. 30th November.
But we have not filed any affidavit because all the records are there. So lordship can-
তাহলে affidavits are complete লিখো না, all the
All the
records are
records are
before the
before you.
court. Stop.
Item 13.
ঠিক করে announce করো।
13 would be the same order, my lord, identical.
Yes, same order.
The unit would be different. Unit only unit. The shop room
What
is-
unit?
The shop room, there are two shop rooms.
I have not mentioned any shop
Oh,
rooms. Have I?
No, lordship. Can.
Yes. Yes. Next. Anybody waiting for the other matters which are in the list? Because I'm going to call on the new chamber applications after this. New chamber. Dakho.
New chamber matters. Item number 69, Rajesh Shardarmal join.
Pray to them. Yes, Mr. Mukherjee.
Yes, my lord. My lord, your lordship.
Dismissal of the execution application.
Yes, my lord. Now, my lord, here, my lord, we have come out with an application, my lord.
You're the award, you're the award or the judgment debtor?
My lord, we are the debtor, my lord. My lord, this is, my lord, lordships have a list of dates, my lord, which was handed up on the last occasion.
Color coded.
Yes, color coded. Now, my lord, there are 3 points, my lord, which, my lord, I wish to urge. My lord, apropos, my lord, these proceedings as to why the execution should not proceed. My lord, what is, first is, my lord, that, my lord, in a challenge, my lord, to, my lord, the provisions of, my lord, the IBC, my lord, an order has been passed, my lord.
Mr. Mukherjee, what is this color coding for in terms of limitation or the claims?
My lord,
This green, what is
my lord,
this?
what are, my lord, during the period of interim moratorium and, my lord, if your lordship sees the key at page 2, my lord. My lord,
No,
green-
so red is what? It's like the color coding as in a traffic signal.
No, not, my lord, different items, my lord, it's got nothing to do, my lord, with. my
No,
lord.
so the red is a no-go and green is.
No, no, no,
or-
my lord,
okay.
all are no-goes, my lord. All are no-goes, my lord. My lord, I'll tell your lordships, my lord, here, my lord, a suit, my lord, had been filed, my lord, before the Sharjah Federal Court.
What federal court?
Sharjah, my
Sharjah.
lord, Federal Court. My lord, if your lordship takes the first date, 14 September 2020,
Yes.
lordship will find, my lord, suit filed. My lord, there were several others, my lord, who were parties, also, my lord, against the respondent before Sharjah Federal Court by the petitioner. My lord, then, my lord, kindly see, an application had been made, my lord, under section 95 of the Insolvency and Bankruptcy Code my lord, against, my lord, my client by Central Bank of India seeking initiation of insolvency proceedings. Now, my lord, under the act, my lord, if your lordship takes the act, my lord, once,
Yes.
my lord, that's, my lord, section 96. When an application is filed under section 94, section 95,
Yes.
an interim moratorium shall commence on the date of the application in relation to all the debts and shall cease to have effect on the date of admission of such application.
Yes.
So, my lord, this was, my lord, what was, my lord, filed under 95(1), my lord, against, my lord, my client. And, my lord, as on that date, my lord, the interim moratorium, my lord, continued. Then, my lord, 16 September, order passed by the National Company Law Tribunal, Kolkata, appointing a resolution professional. 28th December 2021, order passed by the Sharjah Federal Court, partially allowing the petitioner's claim. However, the Sharjah Federal Court held that the petitioner could not file the suit in his personal capacity. Appeal preferred by the petitioner from the first United Arab Emirates order seeking inter alia modification of the order to the extent that dismissed the petitioner's case and confirmation of the petitioner's right to transfer ownership of certain shares as mortgage pledged to him by the defendants in the suit.
So this list of dates is by the judgment debtors.
Correct, correct. So, my lord, the first point your lordship will find that, my lord, the suit, my lord, proceeded, my lord, in spite of, my lord, the moratorium, my lord, interim moratorium, my lord, which had been declared, my lord, by virtue of, my lord, the statutory provisions of 96. And, my lord, not only that, my lord, order was also passed, my lord, while that moratorium was in operation, and an appeal, my lord, was preferred, my lord, from that order. Then, my lord, kindly come to 26th April 2022. Now, my lord, here I wish to show your lordships, my lord.
Why has the color changed, Mr. Mukherjee?
Because now, my lord, the interim moratorium continues till the date of admission. My lord, after admission, my lord, there is another moratorium, my lord, and my lord, which your lordships will find, my lord. If your lordship looks at, my lord, section 96 once.
I saw that till the date of admission.
Correct. And, my lord, no legal action can continue, my lord,
Yes.
which is why, my lord, all those come under, my lord, green.
Yes.
And then, my lord, your lordship kindly comes to, my lord, section 101.
Yes.
My lord, when the application is admitted under section 100, which is what happens here,
Yes.
a moratorium shall commence in relation to all the debts and shall cease to have effect at the end of the period of 180 days, beginning with the date of admission.
Yes.
So, my lord, this is the second moratorium, my lord, which commences, and, my lord, has a lifespan, my lord, under the statute, my lord, of 180 days.
Yes.
So that, my lord, happens on 26th of April 2022. My lord, the matter still proceeds, my lord, in the Sharjah Federal Court. And, my lord, your lordships will find, my lord, an order is also passed allowing the petitioner's appeal.
So 28th July 2022 is the end of the 180 days.
My lord, what happens, my lord, is, my lord, on 28th July 2022, there is an arrest, my lord, of all proceedings. My lord, I'll tell your lordships, my lord, what happened. My lord, there is, my lord, a Supreme Court order, keep the 8th July 2020. Give me 8th July 2022 of Supreme Court. I have. Well, kindly give me a moment.
Yes.
29th April, that's. You have 29th April. My lord, there was a challenge.
Mr. Mukherjee, I remember those orders by the Supreme Court. One or
Yes.
two orders
Yes, my lord, what had happened, my lord?
in some other proceedings.
Yes, my
please.
lord. the-
Challenge to the IBC, some
Correct.
sections of the IBC.
Correct, my lord. These are, my lord, the provisions relating to, my lord, individual, my lord, corporate insolvency, my lord.
And there was a stay granted in all.
Correct. So, my lord, the entire proceedings were arrested. So, my lord, I make, my lord, two submissions. My lord, apropos this. Just take them out. First 28, 29 paper, and then my lord, I have this 29. My lord, kindly take, my lord, the first order, my lord, of 29th April 2022.
Yes.
My lord, the challenge, my lord, to my lord, these, my lord, provisions. My lord, there was a notice issue, and my lord, there was an injunction granted, my lord, on, my lord, the, my lord, debtor, that they will not transfer, alienate, encumber, dispose of any legal rights, and the resolution professional, kindly note this, shall not proceed with filing of the report.
But Mr. Mukherjee, weren't these orders restricted to those debtors who had
No, my
gone to
lord,
the
then
Supreme Court
My lord, it happened to us as well. Yes, my lord, I want to show you.
Yes, it doesn't matter. If you say so, it's
Yes,
there.
my lord,
Yes.
kindly take the list of dates, my lord. I'll give you a lordship the order.
That's fine. I don't really see the order.
My
You
lord,
just tell me yes.
28 July 2022.
Yes.
Order passed by the National Company Law Tribunal, Kolkata, recording stay of proceedings ordered by the Honorable High Court at Calcutta in light of the Viris challenge to section 94 to 100 of the Insolvency and Bankruptcy Code, and to extending to respondent number 1 herein the stipulations imposed by the Honorable Supreme Court in orders dated 8 July 2022 and 29th April so and so, restraining transfer, alienation of the personal guarantors, assets of beneficial interest. So, my lord, there was a same order, my lord, was passed, my lord, on 28 July, my lord.
Yes. In your matter, in the
Yes,
Supreme
my lord.
Court.
Kindly have a look,
Yes.
my lord. This is, just give a copy. Why you thank?
Yes.
My lord, this is, my lord, the Central Bank of India matter, which is, my lord, the matter here.
Yes.
Learned counsel on both sides present. The Honorable High Court of Calcutta has in so and so in the matter of Arun Kumar Jagatramka versus Union of India, challenging the Viris of so and so, state further proceedings in the matter on so and so. Referring to an order of the Honorable Supreme Court dated 29th April, the said order of the Honorable has restrained the person from transferring or alienating so and so. This stipulation, which is reiterated by the Honorable Supreme Court in an order dated 8 July, would also apply. In view of the above, we adjourn the matter to so and so with liberty to mention the matter if the judgment of the Supreme Court is received. This is in this very matter.
And what is the connection with this WPA, Mr. Mukherjee? Paragraph 2 of the order.
No, that's another matter, my lord, where, my lord, same orders had been passed.
Yes.
So, my lord, NCLT then says, my lord, that the orders which are passed, my lord, in 2 Supreme Court matters and the High Court matter, my lord,
Yes.
would, my
Very
lord, apply to these proceedings. And, my lord, this comes before expiry.
All
My
the
lord,
180 days.
100 and, my lord, 80
80
days.
days.
So, my lord, my first submission before your lordship, my lord, is, my lord, that this, my lord, arrests, my lord, further proceedings under the Act.
Yes.
So, my lord, the moratorium, my lord, period, my lord, has, my lord, not expired as yet. Because it's got 180 days to run, my lord. What is interdicted by court, my lord, has to be, my lord, excluded. That is, my lord, the first submission which I make. And, my lord, your lordships will find, then, my lord, comes, my lord, the red orders, my lord. My lord, those.
So, so up till now, you're relying on 95, 96, 101 and the orders of the Supreme Court.
Correct. So, my lord, it is certified judgment and writ of execution issued by Sharjah Federal Court for execution outside UAE. Execution notice sent to the respondents. Now, my lord, kindly note this. It is sent to an incorrect address. I'll make that good. Now, my lord, 11th February 2023 execution case filed by petitioner. So, my lord, my first submission is, this is during, my lord, the moratorium period. Because, my lord, the moratorium period under statute, my lord, has been interdicted by virtue of orders, my lord, which have been passed by.
And the 180 days ended when, Mr.
My lord,
Mukherjee?
would have, if not interdicted, my lord, 6 months from 26th April 2022, which would have been, my lord,
October.
23rd October 2020.
Yes.
And my lord, so my lord, this is my lord the first submission, which I make my lord before your lordships.
So the respondents, Mr. Mukherjee, the judgment, the decree holder is relying on the Sharjah,
Correct.
the Sharjah court proceedings.
Correct, correct. That's the order, my lord, which they seek execution. My lord, it's a reciprocal, my lord, territory. So, my lord, they, my lord, seek execution on this. Second, my lord, second reason why I say, my lord, execution cannot be, my lord, proceeded with is, my lord, that there is, my lord, an order of injunction, my lord, which has also been granted, my lord, against my clients, my lord, from dealing with the assets. My lord, that is, my lord, by
The
national
NCLT.
NCLT. That's the second point. And my lord, the third point, my lord, which I say, my lord, cannot at all, my lord, why they cannot rely on this decree, my lord, is, my lord, number one, my lord, this is, my lord, passed, my lord, ex parte, the decree, and my lord, without notice to me.
That's a Sharjah court decree.
Correct. Now, my lord, kindly have a look at, my lord, section 13, my lord, of the Code of Civil Procedure.
And Mr. Mukherjee, these provisions will hold good for the Sharjah court.
My lord, I have not argued that, my lord, that Sharjah court cannot proceed. My lord,
Yes.
that's a possible argument, but I have not, my lord, made that. What I'm saying is, my lord, moratorium, because I couldn't find a case, my lord, that will, the, my lord, moratorium, my lord, provisions, my lord, would operate trans-border. My lord, I tried looking at, my lord, trans-border insolvency proceedings, but that is a question which could arise, my lord, in these proceedings. But my lord, most importantly, my lord, moratorium period has not expired because it's been interdicted. So the execution, my lord, has been filed, my lord, after the interdiction.
Yes.
Second, my lord, there has been, my lord, there's an order of injunction. And third, my lord, that no reliance, my lord, can be placed, my lord, on, my lord,
Ex parte.
the ex parte. Kindly have a look, my lord, at section 13, my lord, of the Code of Civil Procedure.
Yes. Yes, Mr. Mukherjee.
My lord, kindly see, my lord, a foreign judgment shall be conclusive as to any matter thereby directly adjudicated upon between the same parties or between parties under whom they or any of them litigating, claim litigating under the same title, except, my lord, kindly come to, my lord, D,
D, natural justice.
yes, where the proceedings in which the judgment was obtained are opposed to natural justice. Now, my lord, here your lordships will find, and my lord, kindly have a look at section 44A also, my lord.
Yes.
My lord, it's, my lord, a reciprocating territory, my lord. I'm not, my lord, joining, my lord, issue with regard to that. It can be executed, being, my lord, a reciprocating territory. Now, my
And
lord, kind-
Sharjah is a reciprocating
Yes,
territory. Yes.
my lord, it is. Now, my lord, kindly have a look at, my lord, the order once, my lord, the first UAE order.
Mr. Mukherjee,
Yes.
how much time will you take for this?
My lord, 15 minutes, 20 minutes, my lord,
I don't think so.
but maybe. We can come back another day, my lord. On
No,
this.
you have to, Mr. Mukherjee,
Yes.
because you will show me the Sharjah order, then
Yes,
the natural justice point.
yes, that'll, my lord, I'll have to.
And then, of course, all the other parts you've covered, or you only have that natural justice point left?
Natural justice, my lord, the
Only
others are on
section
the
13.
statute, my lord, and my lord. My lord, one case I might cite there about interdicting of, my lord, the moratorium. My lord, that period has to be excluded. My lord.
Case of the Sharjah court.
No, my lord, here, my lord, here. My lord, here itself, my lord, because moratorium was interdicted. It had, my lord, another 3 months to run. And my lord, it's still running because of the injunction, my lord. So my lord, that, my lord, time has to be, my lord.
So execution proceedings were filed when? Of 2023? You want
Yes,
dismissal of
yes,
that?
my lord, but my lord, correct. But my lord, my submission before your lordship is, my lord, by then, my lord, proceedings before, my lord, the adjudicating authority had been arrested by virtue of court orders. Now, my lord, once it gets arrested, my lord, everything, my lord, till the period that it is, for the period that it is arrested, my lord, the period of moratorium also gets extended.
So the 95-96-101, that is 1 point. The Supreme Court orders, not 1 point, that is 180 days. 180 days got over sometime in October 2023. The Supreme Court order is the other point covered by the NCLT, followed by the NCLT, that's of July 2023. That arrest is continuing till
Correct.
date? It is.
Yes. And then, my lord, is the
So
order.
180 days is over,
No, 180 days according to me is not over.
not over.
Not over, because my lord, once interdicted, my lord, that period has not run. It has to be, my lord, an uninterrupted run of, my lord, 6 months. My lord, by virtue of orders of court, my lord, that period, my lord, has stopped running. My lord, after, my lord, that 3-month period.
Very well. Mr. Mukherjee, you clarify this part
Yes.
on the next day.
Very well.
Are you for the
Yes.
the award,
Decree holder.
the decree holder?
Lordship.
Learned counsel appearing for the judgment debtors has made his preliminary submissions, including on the relevant dates.
My lord, I appear for only one of the judgment debtors.
One,
Yes, my lord.
Two is in liquidation.
My lord, number 3, my lord.
One.
Number 1, my lord.
Lordship, only one, Lordship may be permitted to submit.
sorry, microphone, please.
They have said there is a violation of natural justice, no surveys and ex parte. We have documents to show that we have served at Sharjah.
No, I will hear you, of
Your
course.
Lordship.
Yes, learned counsel appearing for the judgment debtor number 1.
Opposition. Excuse me.
Submissions, including on the relevant dates, starting from the suit filed by the respondents in the Sharjah Federal Court. Stop. Council has taken the court through the provisions under the Insolvency and Bankruptcy Code 2016 and the orders of the Supreme Court and of the NCLT, Kolkata, to show that, to urge that the proceedings were and remain arrested. To urge that the execution proceedings were and remain arrested. Stop. Next, list this matter. Mr. Mukherjee, what is the risk you run? They have started to execute.
Well, they filed an execution. My
They
lord,
have filed their execution.
I have made this application in the execution.
No, that I've understood, but they've no steps taken or no orders in the
Your
execution.
Lordship, there was an order of.
Microphone, please.
There was an order of stay on the, not to proceed with the properties and the shares that was.
Passed by this court.
Lordship, they were passed, but subsequently it was not extended. when
What
they
is what is the order, Mr. Mukherjee? Stay.
No, my lord, that I will not sell.
Yes,
To
they will not
alienate,
deal.
my lord, 21st April 2023. And my lord, that, my lord, has, my lord, expired. But my lord, I am already, my lord, restrained by an order of the National Company Law Tribunal.
Very well.
Because I have already been restrained.
yes. List this matter. Next, list this matter on, tell me, Mr. Mukherjee, when you want to come back this side of the vacation?
I don't know. Lord, I leave it to your lordship.
No, completely up to you. There's no problem in hearing you.
Lordship, only one thing I have not used a opposition. because they have to place their application first. They are placing, so if need arises, Lordship, the leave to file my opposition,
Then let
bringing
them
on
take
record the,
After in opposition.
because they are saying violation of natural justice, but I have to show that.
No,
they
no,
are
how much
served.
time will you take? Tell me.
Lordship, more 4 weeks, because he's in Dubai, he come back 4 weeks, Lordship.
What's in Dubai?
The petitioner is from the decree holder is from Dubai.
My lord, Indian origin.
As opposed to maid. Yes, next, learned counsel appearing for the decree holder seeks to file an affidavit in opposition. Stop, affidavit in opposition within 4 weeks as prayed for. Stop, reply by
My lord, 2 weeks thereafter, my lord.
within 2 weeks thereafter. Stop, 6 weeks will take us when? 2024?
No, my
No.
lord, my lord, kindly put it in the
The
second.
short holiday.
Yes, my lord, the short time that we have court, my lord, November to December.
Yes, illicit matter. Give me a date in the last week of November. Court reopens on the 4th, 28th, 29th, 30th, whichever. This has to be a Tuesday or a Thursday. 30th,
Very well, my lord. That's a third, yes,
30th?
30th November.
illicit matter on 30th November 2023. Yes, follow the next matter, please.
70 contemporary brokers.
Time for the decree holder. This matter, my lord, there was a consent decree, my lord, passed, my lord, in
Yes,
2022. And the last occasion, my lord, the last two orders, my lord, they've been promising, my lord, to pay, including, my lord, the last order. My lord, there's all only, my lord, promises, my lord, they're in.
My lord, I appear for the,
1 minute, just let me see the order, please. You're referring to the 5th September?
Yes, my
order?
lord, 5th September 2023 order, my lord, refers to, my lord, the also
2 crores.
2 crores. My lord, that is only, my lord, under the decree. Now, if they default, my lord, the entire decree becomes, my lord, payable. That is, my lord, of course, a larger sum, my lord, 1 crore 87, my lord, and 5 crore 37.
You're appearing for the
judgment debtor, Lordship.
judgment debtor.
I'm
Yes.
seeking for a short passover. I'm being led by Mr. Jishnu Chaudhary. He's on his legs, Lordship.
Why you just tell the court
My
that
lord,
you can pay or not
My
pay?
lord, we have already paid 25 lakhs yesterday, Lordship.
Yesterday.
Yes, ma'am.
No, the order of 5th September records 50. No, records at 50 lakhs, you said that 50 lakhs, that you will pay 50
Lordship,
lakhs.
That-
instead,
Sorry.
Lordship, instead of 50 lakhs, what we could manage
Now
yesterday,
25 lakhs remains.
now 25 lakhs, Lordship, out of the total till 31st August, 2 crores was remaining. We had undertaken to pay 50 lakhs out of the 2 crores. We have managed to pay 25 lakhs and now 25, I am under instruction, Lordship, that by next Monday, a further 25 lakhs will be paid.
So then how much will be remaining?
1.5 crores will be remaining, Lordship. And our next installment, Lordship, is on 30th November 2023. And looking at the
Next installment of how much?
next installment, Lordship, of 50 and 50 and 50.
No. Sorry, my lord, learned friend is totally wrong.
50 and
Lord,
50.
Already, my lord, 2 crores was due, my lord, as on 5th September 2023. That's the default amount. And my lord, he promised, my lord, that's the undertaking. He says, my lord, he'll pay the entire amount, 2 crores, along with interest 2,78,000 by, my lord, within 2 weeks. Kindly look at, my lord, the order of 5th September. I'm sorry, my lord, my learned friend is not, my lord.
No, and what has been paid? 25 lakhs?
Yes, and just before, my lord, what happened, my lord, even before the previous order, my
Yes.
lord, when they're in default, they, my lord, just make this paltry amount, my lord, payment so far as the decree is concerned, and then, my lord, come and say that we have paid this amount. 25 lakhs, my lord, is nothing. It's 2 crores, my lord, which they were supposed to pay within 2 weeks. On, my lord, 5th September. Kindly, my lord, have a look at, my lord, the second paragraph of my lord's order. And that was the, my lord, previous order also. This is what they did. They were in default, my lord, for payment of, my lord, 1 crore. They, my lord, paid again, my lord, some amount, and they said we can't pay the rest. And that was also carried over. Kindly see, my lord, learned counsel appearing for the decree holder, second paragraph, submits.
Yes,
that
yes, I've seen that.
Yes. And then learned counsel appearing for John prays for time to make the balance payment within 2 weeks from date. And before that also, my lord, 28 June, records that the judgment had prayed for an adjournment, assured the court
that rupees 50 lakhs would be paid to the decree holder by 16 July 2020. Further undertook to pay 12% on the default amount, which was to be calculated. This is also
Which we did, Lordship. On 14 July, we had paid 50 lakhs. 25, Lordship. Lordship, if I can just take you to
Very well.
page
So
6.
after 5th September, how much have you paid? 25 lakhs.
After 5th September, 25 lakhs has been paid, and I'm under instruction, Lordship, that a further 25 lakhs will be paid by next Monday, Lordship.
You're supposed to pay 2 crores.
My Lord,
That's the order.
So you would have given by next Monday,
another
50 crores of the 2 crore, 50 lakhs of the 2 crores promised.
50 lakhs of the 2 crores promised, Lordship. My Lord, if I can just take you to page 6, Lordship.
No, just there's no point in going through documents. Just you're not in a position to pay more or to honor what you have assured to the court on 5th September.
My Lord, I am under instruction that a further 25 lakhs we shall be paying by next Monday, Lordship. So if the matter can be placed on next Tuesday for that.
Mr. Banerjee, you don't want to be satisfied by the driblets.
Lord, we also, Lord, there was a little history behind this was, Lord, there was a larger sum. We agreed because they came and said that I'm agreeing to a consent decree. We gave up, Lord, a part of the principal amount. We gave up interest and said, if this is the manner in which you pay, we will accept it. Because they came and said, Lord, their group companies, everyone is
No,
under difficulty.
the manner which you say is recorded somewhere.
Yes,
that the
yes,
parties
it's a
agreed
decree.
to
Yes,
this.
yes, it's a decree.
Very well.
It's a decree. Lord, I was praying, Lord, either should proceed with execution to say, they should not really operate any of their bank accounts, or they make a serious.
There's a stay on the execution.
No, my lord. This is, my lord, the order which has been passed, my lord, in the execution with regard to, because they come and say we will pay. In fact, my lord, on the 5th September also, my lord, that's what they said. They said, told court, my lord, they will pay, my lord, that 2 crores, my lord, the balance. My lord, I'm only, my lord, worried that, my lord, this should not be, my lord, a way, my lord, extend the period of the decree and then, my lord, knows.
Prevent execution.
Yes, and, my lord, then, my lord, insolvency is always there. Then, my lord, I hope, my lord, that's not the way, because, my lord, some of their companies, my lord, did go, my lord, into, my lord, insolvency.
But haven't they come out of it?
We have come out.
One of them, my lord, has come out. My lord, let them give a guarantee or something, my lord, that one of the companies, my lord, let them give a guarantee. At least, my lord, I'll be satisfied if this is, my lord, how they, my lord, keep on paying. My lord, that on instruction, my lord, they can also take.
Guarantee on the remaining 1.50.
Yes. My lord, the remaining is, my lord, 1 crore 87 and 5 crore 37.
That, my lord, is till November 2024.
The terms of the decrees, if there's default, the entire amount becomes due.
No,
My lord,
what is your learned friend saying, you are Mr. Ghosh?
Yes, ma'am.
Sorry. Mr. Banerjee, what is Mr. Ghosh saying that about this 30th November thing?
My lord, the next installment, my lord, in one of them, my lord, there's 2 plaintiffs, my lord, are there. There's one decree, my lord, which is for 3 crore 50. In so far as plaintiff number 1 is concerned, it's the same, my lord, transaction. And plaintiff number 2, my lord, is about 8 crores.
One is contemporary. Who's the other one?
My lord, contemporary.
Brokers and
one is
targets.
target, one is broker and one is target.
Now, my lord, contemporary brokers, the
And my lord,
installment,
this is it, my lord.
the installment ends on 30th November.
No.
And the last installment is 100.
Ghosh, I'm sorry, perhaps this is broker, and please look at it.
Target. I'm coming to target, sir.
So,
Target, my
Mr.
lord,
Ghosh,
is
in any event, even if I were to discount what your learned friend is saying, there are 2 instances at least where you have come and told the court that you will pay a certain amount of money within a fixed time frame. Why should I go back on what was agreed between the parties and all that?
My lord,
The 2 crores have to be paid along with whatever the other amount. Now you're saying 30th November. That doesn't appear to be recorded in any of those orders.
my lord, in the last 2 occasions, we had undertaken to pay 50 lakhs, which we had done on June and 14th of July.
That is the coordinate benches order. What
Yes,
about the other one, 5th
The new-
September?
The 5th September order, Lordship, we could manage to pay 25 lakhs yesterday, and we can pay another 25 lakhs by Monday, Lordship. And
Very
then
well.
there
So
will be
then
1.5.
again, there's a remaining amount.
1.5 crores will be
Yes.
remaining, Lordship. My
Yes.
only submission is that the next installment payment for both contemporary brokers as well as contemporary target is on 30th November, Lordship.
No, but that has no connection with the 1.50.
I
That is a
understand.
separate amount
I
to be given.
understand,
Then
Lordship.
how is that relevant,
So
Mr. Ghosh?
after paying 25 lakhs next week, we can try to gather some more funds. Actually, my lord, what has happened is we are facing some substantial financial crunch, as a result of which our intention is to pay, Lordship. Our intention is to pay, which we have shown again and again, Lordship, that whatever we can, we are paying. I'm led by Mr. Chaudhary. Lordship.
Continue, please. Mr. Chaudhary, take your seat. Yes.
My lord, we are showing our intention to pay, lordship. That is why we have paid 50 lakhs, another 25 lakhs. And if we look at the overall settlement term, lordship, we have now 1.5 crores will be remaining after next Monday's payment, lordship. That is, and we will continue
Then
paying.
why are you averse to giving some form of security for that?
My lord, I can take instructions on that and come back.
Give that. Why? What instructions? Give that.
My lord, I will take
Because
instructions
this
and
has
come
been
back. in a-
continuing since at least September in my court.
Lordship. I can take
Mr.
instruction.
Chaudhary,
come.
yes, how do you want to better that? Files, give some sort of security.
The first time, my lord, what has happened is they have not fulfilled their commitment made to council. Because I had said that.
Commitment made to council.
Yes, that I had said
And the
that.
next stage is to the court.
No, normally, my lord, otherwise I wouldn't have made the commitment that by yesterday we would have paid 50 lakhs. I'd made that commitment and they have only paid 25.
2 crores, 2 crores. That's the order, not
I-
50 lakhs.
No,
2 crores.
We had said 50 lakhs. my lord.
No, it's become 2 crores, have become due. Why will you make payment of 50 lakhs? That was the previous time.
I had said.
No, the commitment was made to council because council gave them some other figure, not
No, no.
2 crores.
No, we told them there's a default. They said we can't pay. So, my lord, we said by 50 lakhs, I'll pay and then, my lord, I'll pray for, my lord, further indulgence. They haven't paid 50 lakhs. It's some provident fund attachment issue came up, so they had to divert some money there. They've paid
Mr.
25
Banerjee,
lakhs.
no point in haggling over this,
Yes, well, I-
what amount?
My lord, may I suggest this? Next Tuesday, my lord,
Next Tuesday.
next Tuesday. I'll, my lord, try and gain some equities by making some payment and also, my lord, offer a security. I'll try to, my lord, do that.
And what is the magic date for next Tuesday?
Look,
Magic day rather.
25 lakhs, my lord, and the interest outstanding.
25 lakhs.
That's what I've been.
And then
promised.
1.50 crores remains plus
Lord, it's
plus
a 11
2.78.
It's a 11 crore settlement from, I think, February 20.
Mr. Banerjee, let me direct them to make that 50 lakhs payment. How much? 25. 25 lakhs payment by tomorrow,
By next Monday.
Monday.
Plus,
And then how will you better that by Tuesday?
so if once I do that, I'll be able to, my lord, come and request your lordship for a little more time.
Mr. Chaudhary, I'm directing you that 25 lakhs by Monday and further security for the remaining amount on Tuesday. I'm keeping the matter on Tuesday. All right.
I have, my lord, I can't, my lord, even request otherwise. But I can,
There's a,
if he can't pay, he can't pay. He'll have to face the consequences.
yes.
So he can take, because I was going to request for if the matter is kept on 28th of September, because I have some personal difficulty. The next
28th. Very well.
If he has more time, if he can better that, otherwise, I'll have
Yes.
to then press for
28 should he cannot.
29, sorry, 29.
আরো তুমি 50 lakh টাকা pay করো।
Section.
Yes, sir.
25 by next Monday and another 50 lakhs by 28th. If
So 75.
75. If I can make that payment, I'll try to, my lord, not give us security because that will also be a problem. I'll take instructions, but I know the reaction. Everything is secured to some bank or the other.
We will take 25 and give us the security. The MRLs, they give us security. Guarantee by.
Very well. The learned counsel appearing for the award holder,
Decree holder.
decree holder. Now, learned counsel appearing for the award debtor. No, it's not an award.
No, it's a
Judgment.
decree. It's a decree of
Judgment debtor. Submits that contrary to the assurance given to the court on 5th September 2023, the judgment debtor is in a position to only pay rupees 25 lakhs by 25th September 2023. Stop. Counsel submits that the judgment debtor has paid 25 lakhs yesterday. What did you say? Yesterday. Yesterday, i.e. on 18th September 2023. Stop. council further agrees to pay another 50 lakhs by 29 September 2023. Stop. Next, the 5th September 2023 order records that 2 crores remain outstanding from the judgment debtor, along with interest at rupees 2,78,631 in respect of the individual heads of default.
Yes.
Stop. Next, hence, comma, even if the judgment debtor keeps to its word, comma, i.e. payment of rupees 75 lakhs by 29 September 2023, comma, there would still be rupees 1.25 crores remaining from the judgment debtor. Is that correct or not?
Yes. Defaulted amount.
As
So
from the
120.
judgment debtor on account of default.
Yes, 1 crore remaining.
1 crore.
25 already paid,
25 and
25
50,
next
yes.
month.
Very well. 1 crore. 1 crore remaining from the judgment debtor on account of default. Stop. Next, list this matter on 29 September 2023 as prayed for. Stop. The court will consider passing appropriate orders for furnishing of security for the remaining unpaid amount on the next date, if required.
Great.
If required, on the next date. Next.
Great.
Item 71, RB Rail Products Private Limited.
My lord, I appear for the decree holder, my lord. Lordship's last order of 29th August 2023. My lord, in terms of that order, my lord, we were directed to, my lord, serve copy of the, my lord, execution application, and liberty was also granted to the decree holder to put in a supplementary affidavit. My lord, this exercise is not yet complete. My lord, what we realize is, my lord, if your lordship kindly takes, my lord, the 29th August 23 order once.
Yes.
My lord, we are entitled to a fixed sum of 52,47,189.50, which lordship has recorded in the first paragraph. Apart from that, my lord, we were, my lord, also entitled to, my lord, return of fixed deposit receipts. That is what the decree says. Now, my lord, the fixed deposit receipts particulars, my lord, the decree lordship in the second line has recorded that the deposit receipts are set out in the schedule. My lord, I would, my lord, request your lordship to, my lord, make a necessary, my lord, correction, because the schedule does not, my lord, contain the fixed deposit receipts. What has happened is, my lord, the amount has been converted and is retained by the bank. I just need to, my lord, indicate that in the supplementary. I need some more time for that, and then I will serve and come back. And if, my lord, I feel, my lord, I may possibly have to go back to the, my lord, the suit court and, my lord, seek a clarification with regard to that fixed deposit receipt. I was only praying lordship grants me 3 weeks time to complete this exercise. I am not pressing for any order, my lord, at the moment.
What exercise specifically?
My lord, to put in a supplementary by 3 weeks and serve a copy of the petition as well as the supplementary on the bank.
You're for the decree holder?
Yes, my lord. This is if your
Very
lordship
well.
has
No one appears, but they have not been appearing or what?
no, my lord, since, my lord, we have not served. It was, my lord, the suit was also undefended. My lord, I'll, in terms of your lordship's order, I'll serve
Yes,
this.
learned counsel appearing for the decree holder seeks time to file, seeks time to bring a supplementary affidavit on record. To show what, Mr. Datta?
My lord, to show, my lord, how, my lord, the amount, the other amount in the tabular, if your lordship takes the tabular statement 3A and 3B.
No, wait, I will go into that later. Supplementary affidavit on record, stop. The decree, the judgment debtor remains unrepresented. Stop. Next, leave is granted to file a supplementary affidavit within
My lord, 3 weeks from date. My
3
lord.
weeks from date as prayed for. Stop. List this matter That will take us to what, the last week of October?
Last week of October, if Lordship is kind enough to, my lord, give me one date in the last week of October.
Please this matter on 17th October 2023 as prayed for. Stop. The decree holder will communicate this order on the judgment date.
My lord, one correction, my lord, in the second line of the, my lord, first page of the order.
Yes.
My lord, this expression set out in the schedule may be deleted because the schedule does not contain, my lord, the particulars of the fixed deposit receipts. That would be, my lord, possibly. The schedule only contains, my lord, particulars of a land, my lord, and immovable property, not the particulars of FDR.
Okay, 29th August order.
Yes, my lord.
Which,
The second line, my lord, first page of the, my lord.
Yes,
order.
Council next. Council submits that the order dated 29th August 2023 may be corrected by deleting the by deleting a part of the first line, which says that, which records that the fixed deposit receipts as set out in the schedule. Stop. Council submits that there is no such schedule which can be referred to for recording of the fixed deposit amounts, for recording of the fixed deposit receipts. Stop.
Yes.
Anything else?
That's it, my lord. Grateful, my lord.
Next.
72, Mrs. South City project.
I appear, my lord, for the decree holder. Initially, there was a decree of 7th April 2021 passed by this honorable court for a sum of rupees 2 crores, above rupees 2 crores with interest. We filed
Yes.
an execution thereafter. In course of execution, my lord, some orders were passed. They were restrained from dealing with the property, and our special officer was appointed for selling off 3 flats. Now, while the execution was pending, there was a settlement reached between the parties, a terms of settlement filed, whereby by which about 3.51 crores was agreed to be paid in certain installments with a particular timeline.
Yes.
On the basis of the terms of settlement, the execution was disposed of and the decree stood modified. Some payments have been received in as per the modified decree, about 1.75 crores. There's a default of 1.76 crores on the part of the judgment debtor. Therefore, my lord, the present execution has been filed because, my lord, the default on the part of the judgment debtor to make payment as per, my lord, the modified decree as modified.
And what are the prayers you have?
Yes, my lord. For the time being, my lord, prayer, my lord, F is, my lord, the prayer that I will be praying before your lordship, my lord, injunction restraining them from dealing with their properties and also from operating the bank accounts to the extent, my lord, of the without keeping apart the decretal dues. Principal decretal.
What is the principal decretal due?
1 crore 76 lakh 17,524. That's, my lord, in the tabular statement. On the last occasion, my lord, Mr. Sinha had appeared and I've also served a copy upon him. Disregard. My lord will find, my lord, the terms of settlement.
That's the principal sum.
Yes, that's the principal sum after adjustment of the amounts which we have already received in terms, my lord. Of
And where is the modified decree?
Yes, my lord, page 69 is the order. And the terms of settlement starts from page 71. The relevant, my lord, portion is at, my lord, page 73, paragraph 6 of the terms of settlement.
73?
Well, page 74, my lord, I'm sorry. Page 74 is the relevant portion, but it starts from page 73, paragraph 7, which, my lord, states that the amount which is outstanding, 3 crore 51 lakhs, 17,500.
And this is what, a formal terms of settlement?
These are formal terms of settlement, my lord. Will, my lord, find page 69 is the order recording, my lord, the factum of disposal of the EC on the basis of the terms of settlement. And, my lord, page 75 is paragraph 11, where it is recorded that the decree will stand modified in as per the terms of settlement.
No, that is also recorded in 9.
Yes.
And what is the amount? The mode is at page 74.
The mode is
the
at, my lord,
breakup.
page,
The breakup
yes,
is at
the
74.
breakup and also the timeline by which they have to make payment in installments, my lord, from 20th July 2022 to 20th August 2023.
So that timeline has gone.
Is gone, and my lord will find.
And have they made any payments or
yes,
not?
some payments have been made. Page 76, my lord, is the chart whereby we have stated what the dates of payment which we have received from the judgment debtor. We have received 1 crore 75 lakhs. The last payment was on 21st of April 2023.
Yes.
Page 76.
My lord, your lordship.
No, just one. Gopal Kedar. Yes, Mr. Sinha.
Lord,
Lord, this transaction, Lord, was there's a loan Lord of 5 crores Lord, which was taken by my client.
Sorry.
A loan of 5 crores was taken by my client Lord, in this matter. Lord, that is the case in the plaint
Loan from the petitioner.
from the petitioner.
Yes.
5 crores Lord. Lord, prior to the suit, Lord, out of that 3 crores was already paid. That's also admitted in the plaint. Lord,
Mr. Sinha,
I'm not-
I will
Lord,
hear
but-
you, but are you disputing this table at
No,
74
Lord, I'm not. I'm going. I'm
or
giving,
76
Lord,
rather?
I'm giving the background Lord, just not to in support of Lord, what I'll be ultimately paying before. Lord.
Yes.
So Lord, 3 crores Lord, was paid not before the suit was filed. Lord, the suit Lord, was filed Lord, for about 3.45 crores. The paid in the plaint was about 3.45 crores
Yes.
when the suit was filed. Lord, during the pendency of the suit, Lord, before the terms of settlement, Lord, about 1.5 crores was also paid.
Yes.
For the sum of rupees 1.5 crores. And not after the decree has been passed, not a sum of rupees 1.75 crores has also been paid. So not as against a loan of not 5 crores, not we have already paid 6.25 crores to my friend's client. So not I'm just not saying this not to not establish my clients, but bona fide, not they are not
6.525
crores, not totality, not so principal plus one interest of 1.2 crores, 525 crores already been paid. So not what remains not is really interest, not on the original transaction. Now, Lord, what has happened, Lord, this, Lord, my client, Lord, the main person, Lord, of my client. Lord,
No, you're talking about a suit which is before the modified decree.
yes. Lord, I'm
Yes.
talking about the transaction, not that we have
Yes,
paid.
yes.
But not, I can't, Lord, as per the decree, Lord, I can't dispute the amount, Lord, which has been paid. But what, Lord, we were paying, but what happened was, Lord, Lord, one of the, Lord, the directors, Lord, the main person, Lord, Senior Mr. HON'BLE Singh, Lord, he, Lord, was not diagnosed with blood cancer. And Lord, his treatment, Lord, took toll on the company. And Lord, we started defaulting. So, Lord, I have taken instructions, Lord, we want to pay, Lord, kindly give me 2 weeks time, Lord, I'll come back with a proposal, Lord, how we can pay, Lord, in the change circumstances.
No, you're referring to 76 is what, Mr. Bhattacharya?
76 is the
is what they have
Amount
paid.
what they have
amount
paid in
paid,
terms of
what we have paid.
And what they have paid in terms of the modified decree.
Yes, this is what we have paid as per the modified.
after
decree.
the modified.
And now what remains is, according to you, how much?
Principal sum 1 crore 76 lakhs 17,520.
So not all, I'm saying, not if it could be taken up, not after a fortnight, but I'll come back with a proposal, not as to how not we can liquidate this dues. Not because not if this injunction is granted, not the entire business will not come to a standstill. I'm not given the conduct of the of my client, not having not paid not substantial amount of sums, not in fact, not from the original transaction, not principal plus interest of 1.25 crores not having been paid, kindly not consider this spread.
Mr. Bhattacharya, I will not pass an order today. I will give them 2 weeks time.
I'm very
All right?
grateful.
And then let us see what they come back with.
I'm very
and then-
grateful. Great.
Today is the first time. So this is not like one of those automated orders which the court passes. Yes. After hearing the advocate on record appearing for the judgment debtor, one judgment debtor.
Yes, madam. Only done.
Yes, judgment debtor, comma, the court is in, and the fact that the judgment debtor has paid substantial amounts of money in terms of the modified terms of settlement executed between the parties, comma, this court is inclined to grant a fortnight's time to the judgment debtor as prayed for.
I'm very grateful.
Stop. Next, list this matter on 3rd October 2023.
Grateful, Mother, deeply obliged.
Next.
Item number 73, if Calonte you Private Limited.
This was that matter where Mr. Bose had given the undertaking. And your lordship desire was that he should address your lordship on it. And
What is your name, Mr. Banerjee?
I'm sure it's misspelled in the order, like it was Shuddha Sattva Banerjee.
The party's name.
Oh. F. Cologne tie-up.
The way it's pronounced, the way it's given in the list, it's something else.
Clubbed together.
Yes, F. Cologne and Thai has been clubbed together. Yes.
F. Cologne tie-up.
Yes, Mr. Banerjee.
Mr. Bose was to address your lordship because it was an undertaking that he had given. I had tried to address your lordship on the last
One minute,
occasion.
what was does the order say anything?
Uh,
Withdrawing the execution proceedings.
Execution, that was the undertaking that he had given. I had appeared on the last occasion, the last day that the matter was called. And your lordship's desire was that considering he has given the undertaking, he should be the one addressing your lordship, and that's the only way one should actually be approaching the court. But he is in some difficulty today.
Mr. Bose, the order doesn't record.
Moinak Bose, my lord, he was there.
Yes, the order doesn't record his, yes, Mr. Bose on the last.
He
page.
was there.
Yes.
And I had tried to get out of that undertaking, but your lordship felt that he should only come and argue. He was anyways leading me in the matter. Not like we had removed him to get out of the undertaking.
Yes, yes.
He's in
So
some
what is it
difficulty,
that you
my lord.
want?
If we come back next
Thursday?
Tuesday.
Next Tuesday. Yes, Ulysses matter on 26th
20.
September 2023 as prayed for. Next.
$74, bond investment.
Lord, I appear for
Invest
your award.
EFCC.
So this is a foreign award execution that we are opposing.
Yes, my lord. Mr. Banerjee was to address on the point of enforceability, my lord. This is my application for execution for foreign award, my lord, passed by the CAF.
So you're resisting that, Mr.
I'm
Banerjee?
resisting.
Yes.
Needn't be troubled with the papers now. I'll first give a brief
Yes.
overview of what the case is. No, this was a CIF contract. So CIF contract.
This will be the last matter, at least this side. Yes.
So this was a CIF contract that a party in India.
Yes.
So there's something wrong with this mic. I could not hear Mr. Sinha also. No.
Yes.
Yes. Well, the party in India entered into a CIF contract with a party in Dubai for import of Ukrainian or Russian yellow peas. The contract gets into rough weather. The contract refers to GAFTA contract number 88 and 125. There are disputes. It goes before the tribunal. The seat is London. The challenge now on.
So you're on 48.
I'm on 48. And I'm on the executability because there's one, I'll be relying on two decisions. But when a tribunal receives an application, it's its first duty to ascertain the law that applies to the contract, the lex arbitrae. That was not done.
And what was the seat? London.
London. With that not being done, because it's clear under section 40, the seat is in London. So the English law applies. English Arbitration Act, section 46, refers to how this entire decision-making process is going to be done.
1996 Act.
96. And once English law applies, then English Sale of Goods Act applies. English Sale of Goods Act, which is akin to our section 55 here, holds that you can't have a suit for price, which is the same law, where the title has not passed. It's identical. It's pari materia to our 55 here. The entire award has been passed on the basis of a suit for price, on the basis of the invoice, after having arrived at a conclusion that the title has not passed. So my first point is, had the tribunal decided what was the arbitration procedure or the law applicable, then this award could not have been passed. With that not having been done, it's in folio 48(2)(d), where I'll just place that particular section. 48(1)(d), sorry, 2 I'll have to come to later. Enforcement of a foreign award may be refused at the request of the party against whom it is invoked, only if that party furnishes to the court proof that D, the composition of the arbitral authority, not my case, or the arbitral procedure was not in accordance with the agreement of the parties, or failing such agreement was not in accordance with the law of the country where the arbitration took place. This part.
Mr. Banerjee, just look up Gemini Bay of Justice Nariman. May or may not be relevant, but just look it up.
I'll look it up. No? Gemini Bay.
Gemini Bay.
Gemini Bay.
2022. With Justice Gawai, but judgment of Justice Nariman.
I'll look it up. No?
Yes.
So this is my first point of challenge. Because once it comes under 48(2)(d, here lordship will find that failing such agreement was not in accordance with the law of the country where the arbitration took place. Of course, it's circumscribed by that the arbitral procedure was not in accordance with the agreement. So where there was no agreement apropos the arbitral procedure, this is, I'm covered by Justice Langley's judgment, where it says where there is no procedure, then it is the first duty of the tribunal to ascertain the law that applies to the proceeding. Because unless you decide what the lex arbitra is, then you are not applying the correct law to the proceeding. And the arbitration, therefore, is going to, the award is going to be found to be not in derogation of this, was not in accordance with the law of the country. Because the entire, and I'll show those paragraphs from the award, it's based on the invoice that this party, the award holder, has raised against me.
Yes.
Purely suit for price. So immediately, if they had applied the arbitration, section 46, and correspondingly applied the English law, then the lex arbitra would have been the English law. So the English Sale of Goods Act would have come in. That having come in, it would not have, could not have been the award.
And what did the tribunal do? One arbitrator.
I'm sorry, madam.
One arbitrator or tribunal?
Three.
Three. What did the tribunal do instead?
But they passed the award on the basis of the invoice.
No, and taking which law into account?
Well, that is not there. That your lordship will not find the from the award. There is, I'm very grateful. So I would have labored on this, that your lordship will not find a single line on which law will apply. I am aware that the award holder is going to come and argue that in this particular contract, there is a basis which presupposes how to assess damages. But that's not the test.
So the award is just the claim on it's
Claim for
the
price.
awarded amount for damage
Price.
price.
They had a section 9 here before
Yes.
this honorable court. There was an interim award and in the main award. In all three, there's a consistent finding. Disregards the first two, my lord. In the award, there's a consistent finding that the title has not passed.
No, and what is the claim for? Claim for price.
Suit for price.
No, you're saying that Mr. Ghosh may come and argue that there is a mechanism provided for
I'll
in
place
the
that.
agreement.
I'll place that because that was one hurdle that in the conference I also had to get out of to understand the procedure that the tribunal would have to undertake in terms of the requirements of 48(1)(d). Because what is in the agreement, I will be able to show that that has also not been followed. But that will go into the merits. And because it's on the merits, it will still be uncountenanceable, if that's a word like that, in terms of 48(1)(d). Because the procedure is not prescribed. And the law, and I'll refer to that as Justice Langley's judgment, it is absolutely imperative that the tribunal decides which part and which law will apply. Unless you put that party on notice as to the applicability law, the party is prevented from going ahead and arguing. That's one bit of it. By submitting to it, I could have waived it. But the law that you'll apply to the proceeding, that's your first jurisdictional fact.
And if the parties don't argue it, then what happens?
It's
not like a section 3 of the Limitation Act. What happens then?
Well, it's an aspect of jurisdiction. It's something for the tribunal to do. If both parties come before your lordship with a commercial matter, which is not a commercial dispute, even if we've agreed to it, we can't consent to it because there is no agreed procedure. It has to be in the contract. Failing, there is no agreement which allows the tribunal to derogate from this requirement. Akin to 12(5), express, writing, agreement. So by pleadings, I'm not giving into anything.
Very well. Mr. Banerjee, when will you come?
There will be an additional point, Milord, on with regard to, I'll highlight that on the next day. Milord, I am aware your lordship takes, the additional point is with regard to it being in, Milord, against the fundamental policy of India. On these two counts, Milord, I will not take too much of your lordship's time.
Just check out the judgment.
Elementa.
DMRC, no, Alimenta is, yes, it's there, but DMRC of the Supreme Court, but that was on a 34, of course, so part 1, which says that if the statute infracted does not have a public element or something, then you cannot connect it. I mean, you know, that fundamental policy of India and all that. So therefore, that cannot be taken as a ground for invalidating an award. I may be off the mark, but there's a DMRC.
Unlikely,
judgment.
I'll look it up. But Elementa is.
But that's quite recent, the DMRC one. So Alimenta is
I'll
there.
look that up. My only, my lord, I have played for one. indulgence.
Alimenta,
Justice Mishra.
yes, Justice Mishra.
Look, your lordships take up these matters on Thursday. This Thursday, I'm in some difficulty. If I could come back next Tuesday, my lord.
Yes, learned counsel appearing for the award debtor, who seeks to resist the enforcement of the award passed under Part 2 II of the 1996 Act, will resume his submissions. It's not a 34-4, so I can't say resume. Will continue with his submissions on 26th September 2023.
Very good.
List this matter on that date as paid for.
Very good.
Non-commercial matter. Item number 1 for judgment, Trilok Infracon.
Yes, I have allowed the application, but the arbitration agreement says 3. So do you want 3 or 1?
But if my learned friends have no objection, then we can have one sole arbitrator. Anyway, the
One
claim is
sole
that
arbitrator. Yes. Um, This court is therefore satisfied that the present case would fall under 11(6) of the 1996 Act. AP 81 of 2023 is accordingly allowed and disposed of by appointing blank to act as the arbitrator, subject to the learned arbitrator indicating his consent in the prescribed format, etc. The advocate of the petitioner shall communicate this order on the learned arbitrator within 3 days from the date of his judgment, together with the required details of the contact person of the petition.
I'm grateful, my lord.
Item number 2, Mrs. Vision Geoinformatics.
Lordship, by your order dated September 4th,
Microphone, please.
Lordship, by your order dated September 4th, you have appointed one arbitrator in the name of Chameli Shengupto. Lordship,
Yes.
we tried to
Yes,
search.
I found out. Yes, AP 532 of 2023 had been disposed of by an order dated 4th September 2023 by appointing a Namta Diye Devat, page 3, to act as the arbitrator. Stop. This appears to be a mistake through inadvertence. Stop. The name should be MS Debjani Shengupta, DEBJNANI Shengupta. Stop. The order is corrected to the extent as stated above. Stop. All other parts of the order shall remain unchanged.
Item number 3, in the goods of Anuruddh Chamriya.
I won't take any time. This is for us. In reply, my lord.
Yes.
My lord, my learned friend has taken the point that the bank accounts reflect close to 50,000 rupees.
Microphone, please, Mr. Mukherjee.
Sorry.
Yes.
My lord, my learned friend primarily took the point that I had made a argument, my lord, that 50,000 rupees, 2 instances, 1 lakh, my lord, which they have said they have received, that is not reflected in their bank accounts. So they showed their bank account to show that they have in fact received that 50,000 rupees.
Yes.
So there is evidence that there are no other bank accounts. I was relying on that fact that 50,000 is not reflected. Therefore, there should be some other bank accounts also. My lord, will kindly just take that document which they are relying on, my lord, the bank statement. It's at page 13 of the supplementary affidavit. Only this point, my lord, nothing else I need to reply on. The first page, Axis Bank, my lord, my learned friend relies on the 5th and the 8th entry.
Yes.
My lord, there's 10th August 2021 and 17th August 2021. 50,000 each. My lord, will kindly take his affidavit in opposition, my lord, once now, my lord. My lord, if your lordship takes page 6, para 4, Roman 7.
Yes.
My lord, if your lordship 5 lines from the top, my lord.
Yes.
However, between 1st July 2021 and 9th July 2021, I have received a sum of rupees 1 lakh as advance. My lord, when kindly look at the dates between 1st July and 9th July. And my lord, again, it's not one instance, my lord. If your lordship takes page 9, paragraph 10. My lord, after the first 4 sentence lines, I repeat and reiterate that between 1st July 2021 and 9 July 2021, I have received a total sum of rupees 1 lakh in terms of the order of 16th February 2020. I deposited. My lord, so these two amounts are, my lord, on a different transaction. It's not about the 1 lakh which he had received.
Yes.
This is the 1 lakh which was received between 1st July 2021 and 9 July 2021, which he has affirmatively stated, not only here, but also in, my lord, the order from which I am alleging contempt, my lord. If your lordship sees that order also, my lord, it's in the application page 106.
And what is the date shown in the
My lord,
document?
August, 10th August 2021 and 17th August 2021.
Yes.
My lord, will kindly see your lordship's order also, my lord, from which, my lord, I'm alleging contempt.
Yes. Yes.
My lord, at page 105 is the order. At 106, second paragraph. Learned counsel appearing for Neeraj Khanna submits that Neeraj Khanna became aware of the order of injunction on 9 July and some of the properties had been alienated between 1st July and 9 July amounting to a sum of rupees 1 lakh. So his stand at all point of time has been that he has received a sum of rupees 1 lakh between 1st July and 9 July, 50,000 each. That is not reflected in the accounts. This 50 lakhs, 50,000, 50,000, which is on 10th August and 17th August, is subsequent transactions, not what is referred to earlier. That's all, my lord.
And what is the relief you want, Mr.
My lord, rule of contempt be issued. And my lord, I also want, my lord, he himself has said, my lord, that he is ready to either get the money, complete the sale transaction and put the money in, or cancel the transactions. My lord, have the transactions cancelled. There is no point of keeping these transactions there anyway void.
Very good.
Obliged, my lord. But this
Mr.
is only in response.
Yes. Mr. Mukherjee and Mr. Medora, just give me like a 1 page
1 page. Very
with reference to the document page numbers. A learned counsel appearing for the petitioner who alleges contempt on the part of the alleged, who urges contempt on the part of the alleged contemnor, has made his submissions in rejoinder. Stop. Counsel seeks issuance of a rule, capital R, as well as an order directing the alleged contemnor to deposit the amounts obtained by the amounts received by the alleged contemnor in violation of the order dated 16th February 2022 or cancellation of the transactions in question in the alternative. Stop. Next, counsel are requested to indicate their points by September 2023. Stop list this matter on 3rd October 2023.
Just one thing, Milad, subject to correction, Milad. I think Mr. Mukherjee's submission at the end was that not that I have to deposit the money, but
false.
complete the transaction because I'm saying I've not received the money.
My lord, I'm exactly whatever your lordship has written, exactly that. Obliged.
But he's not shown that I've received the money anyway.
Obliged.
Grateful, Milad.
Item number 4, Rohitosh Kumar Kothari.
Lordship, I'm for the petition in your lordship. I'm led by Counsel Mr. Ratul Das, your lordship. He's extremely ill, your lordship. That's why he could not appear before your lordship. I'm praying for not this week, your lordship. Kindly grant me this opportunity, Your Lordship.
Lordship had directed me to serve a notice, my lord, intimating them about the last day's order, my lord. I have done so, my lord.
Yes, adjournment is sought for on behalf of counsel appearing for the petitioner. Stop. On the ground that counsel is extremely unwell. Stop. Next, list this matter. When do you want it?
Anytime in the next week, Your Lordship.
Yes, Mr.
Lordship may keep it any day convenient to your lordship.
List this matter on 28th September 2023.
Much
Obliged.
obliged.
Item number 5, Parijat Tradecom.
It's my section 11.
Pursuant to my lord's order dated 28th of August, we have written a letter since the respondent was not appearing to serve a copy of the application, my lord. This is the letter which was received by the advocate on record for the petitioner on 13th of September. An application may be
You are
served.
appearing for the
Respondent.
respondent. Yes.
A copy of the application may be served and any day, my lord.
You have not served a copy. Very well. Do it.
Serve it now.
Yes, when do you want this matter to be listed?
Any day convenient.
I can't hear you.
Any day convenient to my lord.
Yes, the respondent is represented pursuant to the publications in the newspapers. Pursuant to the substituted service. Stop.
My lord, I think
Pursuant to
there
the,
was no publication has not
completed.
no, published in the Times of India, that's
It
what
has
the
not
order
been
says.
published, my lord. We have
Not been
gone through-
published.
Gone through the list and we have
Yes,
taken the order.
Very well, Kedava, learned counsel, the respondent is represented. Stop. Next, a copy of the application shall be
Has been
furnished.
served. Here and
A copy of the application has been served on the learned counsel appearing for the respondent. Stop. List this matter on 25th September 2023.
Item number 6, Mrs. Art Gem International.
May I please, your lordship, I am for the petitioner. This is 11-6 application.
Can't hear you, microphone please.
This is 11-6 application. I am the petitioner.
Lordship, Mr. Sandeep Kumar Bhattacharya was appearing on behalf of the Union of India in item number 6 as well as 7, Lordship. And after his demise, we have already intimated the department and they are processing the things, Lordship.
How much time will you take?
Lordship, I am not empaneled with the Union of India, Lordship. We have already intimated and they are taking necessary steps, Lordship.
No, how much time will you take? That's what I'm asking you.
Lordship, it is on the department, Lordship. They just requested me to intimate that they are taking steps, Lordship.
Very well, I'm putting it next week. You're the advocate on record?
Lordship, I'm junior to Mr. Bhattacharya, Lordship. Just to intimate.
Yes. Sorry, I'm very sorry about Mr. Bhattacharya. Adjournment is taken on behalf of late Mr. Shondeep Bhattacharya, who was representing the Union of India. Stop. Council submits, learned council submits that the department will take some time to engage a new council in the matter. Stop. Next, list this matter. When do you want it?
Any day, as the lordship. Shall I intimate in the meantime to the railway authority?
Yes. List this matter on next week or 3rd October.
No, lordship, 3rd October I shall not. Next week, lordship, kindly.
List this matter on 29th September 2023. Stop. The petitioner will be at liberty to intimate the respondent in the meantime.
Obliged to lordship.
Grateful, Lordship.
Item number 7, Mrs. Art Gem International.
Same order.
Grateful to lordship.
Item number 8, Mickey Metals.
I appear for the petitioner, this is an application under section 11 of the
Arbitration and Conciliation Act.
I can't hear you.
Sir,
Microphone,
This
please.
is an application under section 11 of the Arbitration and Conciliation Act, my lord. May I, my lord, file an affidavit disclosing the impounded agreement, my lord? Lordship had granted me leave.
And what about the respondent?
Let the respondents were served, my lord, once attempted to be served previously, my lord, that had returned refused. Thereafter, your lordships, my lord, on the last occasion had directed us to serve another letter. We served that. On the very same day, my lord, we received a postal endorsement, my lord, tracking report. Okay.
Yes.
But which, my lord, says that item delivery confirmed. Yesterday, my lord, in the evening at around 6:30, my lord, we then again received this, my lord, the postal, my lord, back. And then, my lord, when we took the, my lord, tracking report, now it shows that it has been refused. And it specifically shows that
Very well. What is the dispute?
my lord, cannot be located. So, my lord, just to be on the safer side, my lord, I'm only praying for substituted service. So that this can be avoided at a later
Where are they
stage.
based?
That they are based at the
24
not the
Parganas.
number, not 24.
Not
Parganas.
24 Parganas. The records show that the respondent has twice refused service of the petition. What have you served? Petition?
Lord, last occasion, will the copy of an order along with the petition.
Petition, stop.
Lord, only one indulgence, my lord. The last record, my lord, it shows that returned addressee cannot be located. But my lord, the endorsement on this, my lord,
Very well.
shows
One of the several endorsements also show that the respondent cannot be located. Stop.
it-
Next, learned counsel opinion for the petitioner accordingly prays for substituted service by way of paper publication. Stop. What newspapers?
any local, my lord, English and one Bengali newspaper.
Yes, let the gist of the prayer in the application be published in, give me English newspaper.
Telegraph or
In the Telegraph, the Telegraph, and in
Bortoman or
and in Bortoman on date.
Lord, it takes some time for the Lord, lordship will give us 4 weeks time, Lord, by the time that will be served.
On
Because my lord, it has to be approved by the
11th October 2023.
Great.
Stop. List this matter on 16th October 2023. 11th October 2023 as prayed for. Stop. List this matter on 16th October 2023.
Great.
The supplementary affidavit is taken on record.
Nine, Rajesh Shah and another.
My lord, I appear on behalf of the petitioner. So this is my section 11 application. My lord, disputes arising out of a development agreement. My lord, the petitioners before your lordship are the owners. My lord, development agreement executed in February 2017, my lord. My lord, thereafter, no steps taken by the respondent developer.
You
which
don't
is
know the
for-
date in February?
Yes, your lordship, this is on 7th February 2017.
Yes.
This is at page 30 of my application. My lord, the arbitration clause, my lord, is at page 49. My lord, thereafter, in pursuance of the development agreement, a power of attorney was executed. My lord, that is dated 14th February 2017. This is at page 65 of my application. My lord, it was the duty incumbent upon the developer to immediately, my lord, apply for sanction plan and carry out soil tests. My lord, nothing was done.
Carry out?
My lord, soil test at the
Soil test.
Yes, your lordship. My lord, nothing was done. My lord, we issued a letter, my lord, on 8 June 2023. My lord, informing that we, my lord, want to cancel the development agreement on account of lack of readiness and willingness on the part of the developer. My lord, my letter is at page 82. My lord, they have replied. My lord, there is no, my lord, reason, my lord, for the delay.
My lord, they have not explained the delay. My lord, their reply is dated 30th July 2023 at page 86. Thereafter, my lord, I have issued a notice under section 21. My lord, on 7th July 2023, this is at page, my lord, 88 of my application. My lord, I will have a claim in damages. My lord, I am praying for appointment of a sole arbitrator.
And they have not replied to your 21. What
No,
is
Your
your
Lordship.
claim? How much is your claim?
Your lordship, approximately 50 lakhs.
Yes, what do you have to say?
Lordship, I appear on behalf of the respondents. I'm opposing this application on the ground that the claim of the petitioner is barred by limitation. Your Lordship, if your Lordship takes page 4 of the petition.
Yes.
Your Lordship, at page 6, they have pleaded their development agreement. It should be dated 3rd February. On 17th February 2017, it was executed. Thereafter, in the next page, at para 10, Your Lordship.
It's 17th February or 7th February?
Your Lordship, it should be 3rd February at page 30. Yes,
But
Your Lordship.
Mr. Banerjee said 7th February.
Your Lordship, if your Lordship takes page 30 of the petition, it's mentioned 3rd February. I think the affirmation was on 7th February. That's.
Third February.
Yes, Your Lordship.
Yes.
Your Lordship, if your Lordship takes page 5 of the petition,
Yes.
para 10, there they have pleaded the respondent since the day of execution and registration of the development agreement has sat tight over the matter and have done nothing. Thereafter, Your Lordship.
Where are you reading from?
Your Lordship, para 10. I apologize, Your Lordship.
Yes.
Your Lordship, 5 lines from the top. In para 10, the respondent since the day of execution and registration of the development agreement has sat tight over the matter and have done nothing.
Yes.
Your Lordship, and thereafter at page 6, paragraph 12.
Yes.
Your Lordship, on June 8, 2023, that's the first time they had issued a notice. That is what they have pleaded. If your Lordship takes a June 8 notice, which is at page 82.
Yes.
If your Lordship takes a page 83, where at paragraph 5 of the notice.
Yes.
There they have stated at paragraph 5, Lordship. My clients state that you have assured my clients that the construction of the multi-storied building on the schedule mentioned land will be completed within 2 years from the date of the agreement. That would come to 3rd February 2019, Your Lordship. We are in 2023. Your Lordship, the section 21 notice was issued on 7th July 2023, which is at page 88. So my submissions are, Lordship, that the claims of the petitioner is expressly barred by the laws of limitation. I'm relying on 2 judgments, one passed by Honorable Justice Indu Malhotra and one by Justice Pardiwala. If I may.
Sitting singly.
Your Lordship. Your Lordship.
Sitting singly.
No, Lordship, I apologize.
So Nautel and B and TAG.
Yes, Your Lordship.
Yes, what do you do? How do you defend the limitation?
My lord, in respect of contracts relating to immovable
I
property.
can't understand.
My lord, in respect of contracts relating to immovable property, my lord, time is usually, my lord, not treated to be of the essence. My lord, this is my first point. Secondly, my lord, the time would start running, the 24 months to complete construction, my lord, would start running from the start of the construction. My lord, this is at page 41 of the development agreement. Lordship kindly sees Article 7, time. My lord, clause 21.
43.
41, your lordship, of my petition.
Yes, Article 7, yes.
Yes, your lordship, that the developer shall complete the owner's allocation within 24 months from the date of starting construction work. My lord, this was never done.
Yes.
If the developer fails, then there is a provision for extension of a 6 more months.
So construction did not start at all.
No, your lordship, nothing was done. And moreover, my lord, if your lordship kindly sees page 37,
Yes.
my lord, Article 2 plan, my lord, immediately after execution of this agreement, developer in consultation with a qualified architect shall prepare a plan for construction of building and submit this. My lord, this was also not done. My lord, there is no readiness and willingness. My lord, they have acted in breach. My lord, I have been patiently waiting.
No, no. You have to address on the law. What do you mean on readiness, willingness? I'm not the arbitrator.
Lordship, on account of limitation, my lord, time was extended between the parties by conduct. My lord, time has not started running in terms of.
If you want to take recourse to section 18 of the Limitation Act, there has to be an acknowledgement in writing. Is there any such acknowledgement?
Your lordship, there is no such acknowledgement. But my lord, my claim arises, my lord.
What about Articles 55 and 137?
Lord, there is no specific notice, my lord, of the date on which, my lord, they refuse to perform. My lord, they still want to perform. If your lordship kindly takes the reply, my lord, at page 86 of my application. Lord, we had said that we had been patiently waiting on account of your inactions. You have done nothing.
So you have been patiently waiting from?
My lord, from
2017 to 2023.
Lordship.
Did not run out of patience.
My lord, COVID was there, my lord. From 2020 to 20.
COVID was there.
My lord,
COVID was where?
My lord, COVID pandemic had set in, my lord, which is why.
From 2017 onwards?
No, your lord, from 2020. My lord, my lord, we want this contract to be performed.
And still continuing. Continue till 2023.
Your lordship, it will, my lord, stop coming into effect from, my lord, 20th February 2022. In terms of the Supreme Court order, my lord, I cannot claim it.
Supreme Court order is from 15th March 2020.
Lordship.
Your agreement is of February 2017.
Lordship. Lordship, on that score, my lord, I'll argue that, my lord, contracts relating to, my lord, immovable property, my lord, time is not of the essence. Moreover, they have acted in breach, my lord.
You have to argue on the section 11. Limitation with regard to section 11.
But if the contract is subsisting.
Not L, B and what TAG, and then if there's any other judgment, maybe Geo Miller, but I'm not sure whether Geo Miller will help you. The breaking point judgment.
Yes. In this case, my lord, the contract was subsisting. They had not terminated. My lord, I kept on waiting.
Very well. Do you want to get ready and come back?
My lord, I shall come.
Because limitation is standing in your way. And you certainly cannot take advantage of the Supreme Court orders. That happened 3 years from the date of the contract. You should have definitely run out of patience.
Your lordship will kindly see the reply once, my lord, at page 86.
You better get ready and argue totally, all right? Not piecemeal. When do you want to come back?
Lordship, any day, your lordship, please.
And you better think about the points which they can take to
Your
beat
lordship.
limitation.
Yes.
All right.
Lordship.
And look at articles 55 and 137 as well, if applicable. Learned counsel opinion for the parties. Seek to get better prepared for the matter. Stop. List this matter when?
On Friday, if your lordship.
Friday.
Lordship.
List this matter on 25th September 2023.
Your lordship, I have some personal difficulty on 26th.
Lord, may I file my affidavit of service?
After the affidavit of service is taken on record.
Item number 10, Sarika Booth.
My application were under section 11.
Sham for the respondent.
Mr. Kormakar? Yes.
Perhaps not this matter was taken up yesterday,
Perhaps why you were not here?
I was not there.
You have come to handhold. Yes,
To try and assist your lordship.
yes.
Lord, first of all, Lord, kindly comes to the cause title. We are invoking arbitration only with respect to Lord 29th of September 2016 memorandum of settlement.
No, what cause title?
Lord, to the
Yes.
cause title.
Yes, yes.
Your lordship would find two dates.
Yes,
We are not, Lord, invoking the arbitration clause contained in Lord September 7, 2012. We
yes.
are only restricting ourselves to 29th of September 2016. This 2012 Lord, agreement is an agreement for sale where certain flats were to be acquired by purchase. That did not happen. Lord, dispute arose.
What did not happen?
Lord, the purchase did not happen. The sale deed, Lord, the sale deed.
You're the buyer.
I am the buyer. I'm the purchaser. Now, Lord, thereafter dispute arose. We invoked Lord section 21 and requested for arbitration. We filed an application under section 11 before this honorable court. During the pendency of that Lord application, parties have settled the matter, had settled the matter, and arrived at a conclusion that performance of that particular agreement need not be required. Lord, the agreement was terminated once and for all. Satisfaction recorded in terms of the second agreement that your lordship would find at page 55, 29th of September 2016.
Yes.
Lord, the order recording that is at page 61. Turns to Lord page 61 once, thereafter I'll take your lordship to that.
61?
My lord, 61.
Yes.
In view of the memorandum of settlement entered into by and between the parties on 29th of
Yes,
September.
yes, I saw this. I saw this.
Now, my lord, now the agreement, your lordship would find at my lord page 55. You kindly got it now?
Yes.
55 kindly turns over. Your lordship would see this memorandum of settlement on 29th of September 2016, supplemental to agreement dated such and such. Although, my lord, it is word is used, my lord, as supplemental.
And what is the date of this? It's
29th of September 2016. Lord, because of the stamp, Lord.
Yes.
29th of Lord, although supplemental has been used, but from the Lord overall gamut of the agreement, your lordship find that a novation had taken place. Kindly turns over page 56.
Yes.
The first clause of the recital, my lord. There is a mention of 2012 agreement. My lord, thereafter the subsequent clause. And whereas due to some differences having arisen between the parties herein, the purchaser on being requested by the developer has agreed to surrender her right and interest in respect of the said flat back to the developer by way of resigning and or cancelling the said agreement, subject to compliance of the terms and conditions stipulated herein. So, Lord, parties decided to terminate that agreement and enter into a new agreement. Kindly turns over. The purchaser, clause 1, page 57.
Yes.
The purchaser has agreed to surrender her right and interest in respect of the said flat back to the developer by way of resigning and or cancelling the said agreement, provided that the developer shall pay. Lord, these are the modalities, how, Lord, the new agreement the parties contemplated. Lord, kindly turns over to 58. Clause 2A. In the middle of the page, my lord, your lord should find a time span has also been provided, 5 months, 15 days.
To do what?
Lord, to pay. Lord, the manner in which the entire refund costing was.
No, you will buy the flat.
Lord, the issue was I will be buying the flat.
So you will have to pay.
Under 2012, I was to pay, I was to get the flat.
Yes.
Now, Lord, because of this dispute, I no longer wanted the flat anymore. So,
Yes.
Lord,
So they will have to refund.
Yes, we both decided to cancel that agreement and come to a new agreement to not only refund with interest and allied costs.
Yes.
Lord, the modalities of that refund and Lord, the allied costs were set out in the new agreement and with a time span given. Lord, that time span could not be Lord kept. That's why, Lord, from page 68 to page 91, your lordship would find, Lord, there are at least 6 to 7 supplementary agreements in consonance with the second agreement, which kept on extending the time. They had partly also performed.
No, I
their
remember
paid
there was a problem in the 21 notice that there were about 7-8 agreements mentioned.
Yes. Now, those agreements I'm talking about now, my lord, making this submission, page 68, my lord, to page 91.
Yes.
But I just cursorily indicate.
No,
to your
no,
lordship.
those extensions were extensions simpliciter or
Only extensions with
or had arbitration clauses.
The arbitration clause was only contained in the second agreement I just placed before your lordship.
Yes.
Because not a question was had arose that the agreement in 2012 had an arbitration agreement. If I have to invoke that, I have to pay the stamp duty and then come back. Now, my lord, why I am arguing novation? Because in the 2016 agreement also, a second arbitration clause was included. If the parties contemplated of a situation that 2012 agreement would continue, there was no requirement for a fresh arbitration agreement. The parties agreed for this new arbitration agreement. The parties had paid money in terms of the new agreement they had acted upon. And thereafter, fresh extensions have also been sought for. Some of the extensions have been met and rest could not be met. That's why, my lord, the new dispute with respect to the new agreement for non-payment of the refund.
But your 21 notice doesn't say that.
Lord,
Mr.
I'll
Kormkar.
take your
Your
lordship to
21
that.
notice says something totally
26.
different.
Kindly, my lord, come to page 96. I'm sorry. This is, my lord, my section 21.
Yes.
25th of July 2022. Lord, prior to that, Lord, the recital with respect to 2012 kindly turns over to page 97, paragraph number 5.
Yes.
Upon filing of the said application under section 11, you had approached my client to settle the matter by entering into a memorandum of settlement, proposing, Lord, this is the amount. My client had agreed to your offer and had accordingly entered into a memorandum of settlement such and such. It was recorded that my client shall render all help and cooperation to you so that the said flat could be sold to enable you to pay off my dues under the memorandum settlement. It is pertinent to state that even such memorandum settlement contained an arbitration clause, being clause number 5 there. Lord, kindly turns over to page 98, clause 9. Or Lord, paragraph 9.
Yes.
It is pertinent to mention that all such supplementary memorandum of settlements were in addition to and/or amendment of the first memorandum of settlement dated 29th of September 2016, which contained an arbitration clause. Under the last supplementary memorandum such and such, you had, Lord, that's the dispute that they could not pay. So, Lord, I am restricting my claim only to, Lord, the 2016 agreement. My claim.
You're not interested in the first one because that's not stamped.
Done away with. It has been done away.
But Mr. Kormkar, novation, at least under section 62, requires both parties to be ad idem for substitution of the earlier contract and the creation of the new.
But that is exactly,
and to be bound by the new one.
Yes, Lord, that is exactly why I placed, Lord, the 2016 agreement. Kindly comes to the page 60.
60. Yes.
Kindly sees, Lord, the signature of the developer. Your lordship would find.
Developer is Mr. Sengupta.
Yes. Developer, and your lordship would find all pages signed by them first.
That is different, but whether it's novation or not, whether the question is, they may have, of course, they have signed. They are not disputing the supplemental agreement, but whether it is an agreement supplemental to the first one or whether it's a novation.
Yes, no, that's why I placed the clauses of the supplementary of the Lord, new agreement, terms of settlement. Lord, in the terms of settlement, your lordship, I have shown your lordship, placed before your lordship, that Lord, specifically the 2012 agreement was cancelled and resigned it.
Very well. I understood what you have to say. Yes, Mr. Sengupta.
Lordship, on the last occasion, your
My-
lordship
my-
kindly sees. Lordship kindly sees, your lordship, the cost IT. 2 agreements, your lordship, arbitration contained in 2 agreements have been invoked. One, your lordship, 7th September and your lordship, 29th September 2016. Now, your lordship kindly takes your lordship page 14 at para 90. They are pleadings, your lordship, in the section 11.
Yes.
The petitioner, having been left with no alternative, had issued a notice under section 21 of the Arbitration and Conciliation Act dated 25th July in terms of the arbitration clause contained in the agreement for sale dated 7 September 2012, memorandum of settlement
Very
dated.
well. All these agreements are there.
Everything has been, your lordship, invoked. Thereafter, your lordship, I have shown your lordship this particular agreement, subsequent agreement dated 29th of September 2016. That is page 55. The heading says it's a supplemental to the agreement dated 7th of September 2012. And thereafter, your lordship, the invocation letter I have shown. Lordship, may I file a short affidavit, your lordship? It's a simpliciter matter. I would not have taken, your lordship, that
What
chance of filing.
simpliciter matter?
If your
What is a
lordship,
simpliciter matter?
in this particular matter, your lordship, this particular arbitration clause contained in the agreement to sell has been invoked. That cannot be done. That's their pleadings, that's their notice.
And
says.
Mr. Kormukar, you don't want to have the stamp duty assessed.
But I do not want the flat. So there's no point, my lord, getting the specific performance of 2012. So, my lord, if I don't want anything from 2012, my lord, there's no, my lord, my respectful submission, there is no purpose for assessing the stamp duty. I'm giving away my claim, lord, on 2012 because both the parties decided to, lord, create a new agreement as a novation. Lord, and your lordship, Lord, I'm carrying one judgment, your lordship, once, Lord.
Yes, yes, of course.
Lord,
If you want to show something,
if
show it.
62, section 62 is invoked,
Yes,
Lord, if the previous contract perishes,
yes.
Lord, along with that, Lord, arbitration clause contained in, Lord, that agreement also perishes, provided, Lord.
Yes, yes, that
your
is
lordship
there.
knows, my lord.
Heyman and Darwin's.
Lord, I need not cite them, Lord.
No, show me, give me the paragraph number.
Yes, Lord. Kindly comes to, my lord, page 371. বলছি কপি দাও একটা কপি দিয়ে দেন আচ্ছা আমার Lord, 11 lines from top, Lord.
Yes.
If a question arises whether the contract has for any such reason come to an end, I can see no reason why the arbitrator should not decide that question. It is clear too that the parties to a contract may agree to bring it to an end to all intents and purposes and to treat it as if it had never existed. In such a case, if there be an arbitration
Yes,
clause.
yes, I've read it. Any other paragraph you want to
But
cite?
this is the only, but that's sufficient. My case is completely, my lord, on section 62. I am not invoking, my lord, 2012, 2016 being a only simpliciter, my lord, money transaction, no stamp duty is required. My only question is non-payment of the agreed amount that they wanted to pay in 2016.
My submission, your lordship, may I, your lordship, file a short affidavit?
To
The
bring
reason-
what?
The reason, your lordship, that they have invoked the agreement, your lordship, to sell, your lordship, where, your lordship, the stamp duty has not been paid.
Not required. I'm disposing of. Yes, the petitioner seeks appointment of an arbitrator through the present application filed under section 11 of the 1996 Act. Stop. Next. The dispute between the parties is evident at several levels, including on the question whether the parties should be bound by the first agreement dated 7th September 2012 or the memorandum of a settlement dated 29th September 2016. Stop. Both the arbitrations, both the agreements have arbitration clauses, contain arbitration clauses. Stop. The problem with the first agreement is that it is an unstamped and unsigned document semicolon. The petitioner, however, does not want to get the stamp duty assessed on that agreement, since the petitioner is not claiming any benefit out of the said agreement. Stop. The second agreement is the one which the petitioner relies on to show that the parties mutually agreed to do away with the first agreement, that is of 7 September 2012, and enter into a settlement, capital S, by way of the second agreement of 29 September 2016. Stop. The contention made on behalf of the petitioner is briefly in support of the second agreement is this. Stop. The petitioner initially agreed to purchase a flat from the respondent. What is this building? Who are you? Developer?
It's a flat.
Purchase a flat from the building
Name is Deja Vu.
from the building name is Deja Vu. You want to say that?
But that's
As it is, there's a limitation angle and you want to say Deja Vu. Ki bole? From the project developed by the respondent, but was forced to change her mind, but subsequently was forced to change her mind by reason of the alleged delay on the part of the respondent. Stop. The parties hence agreed to enter into the second agreement of 29 September 2016, by which the respondent would refund the money paid by the petitioner for purchase of the flat. Stop. The petitioner hence, learned counsel appearing for the petitioner, hence seeks to rely on the second agreement, which is stamped, not stamped, which is a second agreement
page 55.
Mr. Kormukar, if it is not stamped, then how do you get away from paragraphs 117, 118 of NN Global?
Lord, my respectful submission, this did not require any stamping because no interest over the land was created. Lord, NN Global talks about stamping in cases where, my lord, stamp duty, my lord, requires.
Paragraph 114 to 117 of NN Global.
But if no stamp duty is required in a transaction, my lord, then perhaps, my lord, NN Global will not come into picture.
Drafter rakho, kalke rakhchi. Get NN Global and distinguish it, please. Yes, list this matter tomorrow for learned counsel appearing for the petitioner to address on the NN Global judgment, on the post-reference NN Global judgment. Stop.
Item number 11, Mrs. Wow Momo Food.
Lordship, I am appearing on behalf of the respondent. Lordship.
Microphone, please.
Lordship, I am appearing on behalf of the respondent. And the copy of
No, it's
section
a-
11 has not been served upon us
Not
yet.
served. I can't hear you.
Service has been affected from the respondent number 1 and 2.
You're appearing for who?
All the respondents, Lordship, but I have received instruction. It has not been served yet.
Very well, tomorrow. Yes, learned counsel appearing for the respondents seeks time on the ground that the petition has not been served on the respondents. Stop. Learned counsel appearing for the petitioner says otherwise. Stop. Next list this matter tomorrow. Grateful.
Item number 12, Monojit Bhattacharya.
This is my application in the section 11.
Yes.
For the respondent number 1.
Let the petitioner,
Microphone, please.
the petitioner and the respondents have entered into an partnership on 28th August 2019, which was subsequent.
Are you saying there's a dispute or no?
My lord, no dispute at all, my lord. We have called for them by 2 letters.
Call for them means?
My lord, of the petitioner, my lord, to sit. My lord, this is a partnership agreement. Disputes intersect partners, my lord.
Yes.
We have requested them by several letters, my lord, to attend a joint meeting, and thereafter, my lord, the issues can be amicably settled, my lord. Now, if they want to retire and also take their money from the partnership business, we are agreeable to that, my lord. We have sent them letters, my lord. I have 2 letters to that effect, my lord, which I'm carrying to court now, my lord. My lord, now,
No, have you, is there a 21 notice?
yes, my lord, they have given us a 21 notice. We have replied to that 21 notice.
Saying what?
My lord, saying the same thing, my lord, that there is no dispute. Both of us can sit. My lord, there is also a third party, my lord. I do not know whether.
And how long have you been keeping them hanging on the loop by saying these things?
My lord, no. My lord, from my lord, as soon as we have received the letter, my lord, we have asked them to come and participate in the business. Yet they choose not to come, my lord. From 2022 onwards, my lord, I've been calling upon them.
Let the arbitrator decide that whether there's a.
My lord, subject to what comes from lordship, my lord, I do not think, my lord, arbitrator's intervention is required, my lord. If lordships,
Your intervention is sufficient.
my lord, certainly not, my lord. My lord, all I was saying
No,
is
no,
that
you as not in the council, as in the respondent.
yes, my lord. Yes, my lord. If they want to sit with us, my lord, and decide, my lord.
Yes, what do you have to say?
I tell you, Lordship, Lord,
Microphone,
when the after the partnership takes wings, Lord, there were the other
Partnership hasn't taken wings.
Lord, when the business ultimately gained momentum, but I was left alone. I was
You were left alone.
alone.
As if by the other partners.
By the other partners, no.
Ganged up.
My lord, we wrote letters. Thereafter, after this letter for appointment of arbitrator, they have taken recourse of section 9. They have made an
Filed a
application.
section 9.
Yes,
Section
ma'am. We have filed a section.
And obtained
Asking for what?
My lord, asking whether they do not, my lord, create any trouble in running of the hotel business, my lord.
Trouble? What
Mal-
trouble?
I
my
tell
lord,
you,
my
Lordship,
lord, that my lord, they do not file a section 9.
Very well. Tell me what the dispute is, please. Yes.
My lord, if they sit with us, my lord, at least one sitting.
Not at all. You have filed a section 9. Why you should have sat with him before filing the section 9.
We have sent
Yes,
them
yes. Tell me what the
Mal-
dispute
bal-
is.
letters, my lord.
balance sheets has not been provided.
Microphone, please.
Balance sheets were not been provided.
Start from the beginning. Don't say balance sheets have not been provided.
But we have invested certain amounts. There were clauses where we are entitled to certain shares of profits, certain honorariums, certain salaries, which are not being paid
Salaries,
Salaries.
as partners.
as partners.
How many petitioners? One petitioner.
One petitioners, there are 3 partners in the partnership.
The respondent number 2 is not before your lordship.
We have served. There, even thereafter, loans have been taken by the partnerships.
And you are one of 3 partners.
I am one of the 3 partners.
And loans taken? You have taken, who has taken the loan? But by the partnership?
By the partnership.
And then what happened?
My lord, subsequently, we lodged a complaint. Thereafter, it was paid.
I don't understand. Loans taken, you have lodged a
Loans taken
complaint.
without-
What was paid?
I tell you, lordship, loans were taken without our consent, without my consent.
Yes.
When I inquired into the matter, I found that a loan has been taken. The people from whom the loans have been taken, the banking authorities, they're coming after
People or
me.
banks?
Banks, they're coming after me. When I raised this objection, the loan was subsequently repaid by the respondent.
What else? What are the disputes?
Disputes, my lord, I have not been paid my salaries, not accounts were not been prepared. I was not given a portion of my
Where is
profits.
the arbitration agreement?
My lord, arbitration agreement is, my lord, clause 20, which is at page,
Where is the partnership deed?
my lord,
Clause,
partnership deed is at page 11.
yes, and arbitration agreement?
Arbitration 11 is page 24, clause 20.
Clause 20 of what?
Clause 20 of the partnership agreement, dispute resolution, which is at page 24 of my petition.
Your 21 notice?
That is at page 39.
39.
It's 39.
Where have you invoked the clause?
Not at page, next page, page 40.
Have they replied or not?
Not, it was replied, subsequently replied. It was replied.
So where is the reply?
Reply was not annexed with this.
Not annexed.
Not annexed with this.
Why?
petition.
After filing of the
Well,
application?
I tell your lordship, this reply, we didn't receive the reply. We got this reply only in the application under section 9. After this letter, section.
So what? You should have annexed it.
Well,
Where,
that was.
where is the
what-
section 9 order?
Section 9 order, there was an interim order. Section,
That also you have not annexed.
section 9 order is not.
Very well. Half of the relevant documents are not part of the application. Stop. The petitioner is hence given leave to file a supplementary affidavit within, by 22nd September 2023. Stop. List this matter on 25th September 2023. Next.
Item number 13, Mrs. US Infra Developers.
An application under section 11 of
Yes.
the Act.
Respondent number 3 and 4, my lord, I appear for.
Okay, sir. Then may I hand up a copy of a list of dates? Lord, it's only pertaining to the question of limitation.
Last order to the.
In fact, I believe, my lord, Mr. Chaudhary had concluded his
I
submission.
can't understand, Mr.
Lord,
Jain.
my lord, I believe that Mr. Chaudhary had concluded his submission yesterday.
No, almost. Lord, I'll just take, my lord, 5 minutes.
I'll give him 5 minutes, Mr. Jain, and then you can start.
You know,
Yes.
there is a development agreement
Yes.
between the petitioner, who's the developer, and the respondents, who's the owner.
Yes.
Lord, page 18 of the petition is the development agreement.
Yes.
Then, my lord, this is dated 12th of November 2011. Subsequently, my lord, on 29th December 2011, a power of attorney was executed by the respondents, that's the owner, in favor of the developer's nominee. I've annexed that. Then, my lord, this is 2011. I've straight away come to 2019, 12th February 2019, letter issued by the respondents to the petitioner purporting to terminate the development agreement. The letter, my lord, is at page 141. This is, my lord, February 2019. A
Yes.
month later, my lord, 19th March 2019, deed of revocation of power of attorney, which had been executed by the respondents in favor of the petitioner in terms of the development agreement.
Yes.
After that, my lord, 24th September 2019, this is a few months later, my lord, minutes of meeting executed for demarcation of the developed areas in furtherance to the development agreement. So, my lord, parties decided who would have which allocation. My lord, our, my lord, submission is that the termination of the development agreement was waived by the respondents.
Where is that? Where does
I
one
have mentioned
waived?
waived. And there is a pleading to that effect, my lord, in the
Why do you say termination? Where does termination come from?
termination comes, my lord, at, my lord, on first page, 12th February 2019. just after the agreement.
To terminate.
Terminate. This is the letter of termination, 12th of February 2019. After the termination.
Because of the deed of revocation.
No.
Because of the power of attorney.
The deed of revocation is of the power of attorney. That is in furtherance to the termination.
Yes.
But thereafter, my lord, they have acted upon the agreement by, my lord, separating the areas.
So you only have that, the second entry at page 2.
And the third one, which is even better for me, which is, my lord, a development, which is an agreement for sale executed by both of us in favor of a third party purchaser, where we record, my lord, specifically that the agreement is alive. It's, my lord, done in, shouldn't say, my lord, specifically record that the agreement is alive. That's not correct. Where both of us record, my lord, that the development agreement exists.
No, the arbitration agreement is which one? The first one?
The first one in the development agreement.
2011.
What has happened here is development agreement entered into, parties, my lord, perform the development agreement. Landowner alleges breach, terminates the development agreement, revokes the power of attorney. Subsequently, my lord, waives it by acting in furtherance to the development agreement. 2 documents in writing. One is, my lord, the document of demarcation of areas. Second, my lord, is an agreement for sale in favor of a third party, where existence of the development agreement is recorded.
Mr. Chaudhary, there's a chunk of 8 years between 2011 and 2019.
Yes. That is,
and the first thing which happens in 2019 is that respondents trying to terminate the development agreement, whatever that means.
Yes, my lord.
What is it purporting to terminate? What does that mean?
Because
Either they terminate or they don't. What is it? What does this mean?
The purport to terminate is, my lord, their act of termination. I would call it illegal, my lord, which is why we have used the expression, my lord, purporting to terminate. So, my lord, this is a question. List of dates, my lord, pertaining only to the question of limitation, which is why I haven't given the dates, my lord, pertaining to performance of the agreement. So, if your lordship looks at the Limitation Act, Articles 54 and 55 of the first schedule is where my claims would go under, either for specific performance or for damages. It's not 3 years from the date my cause of action arises. My cause of action arises, as per my statements in the petition, in December 2022.
How?
But that's my specific case.
So first you're saying they purported to terminate the agreement.
Yes.
Then you're saying termination was waived. Then you're saying that they again started contending that they will terminate.
Yes. Again starting to give effect to the termination. Now, my lord, if your lordship looks at my petition, I have, my lord, paragraph 24, I have made out a case that the respondents have unequivocally waived and or given a go-by to the purported termination.
You explain that sentence to me, Mr. Chaudhary. That they purported to give a go-by to the purported termination. That's what you read.
Yes.
What does that mean?
That means, my lord, I can terminate an agreement. Subsequently, I can continue to perform the agreement. If I continue to perform the agreement, that means that the agreement is alive. The termination has not taken effect. But the, my lord, it's a Order 7, Rule 11 situation. If I have filed, my lord, a plaint saying that you terminated 5 years ago, thereafter parties continue to perform the agreement, and 6 months ago you again told me that you're not going to perform, that is your failure. That is my cause of action to sue for specific performance. So my plaint, my lord, survives.
So your limitation is getting a fresh makeover every time. They are saying either we will terminate or they are saying we may not terminate.
Lord, Lord, if your lordship looks at it from, my lord, the Order 7, Rule 11, my lord, situation, for, my lord, a suit to be barred by the law of limitation, my lord, it's a tall order. My lord, the plaintiff has to, my lord, commit the suicide. He has to draft a plaint by which expressly shows it's barred by limitation. That's, my lord, extremely difficult. that one will rarely come across a situation where, my lord, a plaint is ex facie barred by limitation. My lord, one sentence will not save the limitation. Now, these are matters, my lord, of performance of agreement. Once the respondent terminates and thereafter, my lord, he continues to perform, agreement is treated to be alive. I am entitled to, my lord, say that he is waived, my lord, termination because he has not taken any step pursuant to the termination. He's allowed me to construct even thereafter. That's, my lord, a case made out. He's allowed me to, my lord, continue to perform the agreement. So, and, my lord, there are two specific documents in writing which, my lord, show that termination was waived. May I only show your lordship, my lord, the second document at page 302.
That's of 2019.
Yes, 2020 to 19th March 2020. That's volume
So
3.
your no activity gap increases from 8 to 9 years.
No, my lord, there's a lot of activity. It's not captured, my lord, in the list of dates. The petition has it. My lord, I'll show you, lordship.
No, just show me the document and that'll be all.
My lord,
Yes.
there are pictures, my lord. Page 87.
Pictures for what?
My lord, the suit property where construction is complete. It's been all activity.
Very good. Show me that one document and that'll be all.
Just that one document, 19th March 2020, page 302.
Yes.
This is the agreement for sale. But kindly, this is the agreement. I'll just show your lordship who the parties are. The three parties. One is, my lord, landowner, who's the party of the first part. Second is, my lord.
Mr. Chaudhary, don't take so much time. Just tell me how you're going to beat
Straight to
limitation.
the clause, my lord.
Yes.
Three part, 311, my lord. T.
T.
Yes, my lord. Subparagraph T 311. On or before the execution of this agreement, the purchaser, who's the third party, has already seen and examined the title of the developer.
Yes.
And the right title and interest of the developer to sell the flat. Now Mr. Jain's clients have signed this document. This is 2020 after termination. So after this, it is not possible for the respondents to say that the agreement was terminated. Because if it was actually terminated, he wouldn't have signed this. I also couldn't have signed this document. So he's waived, all his rights. So,
Even your learned junior can't understand what you're saying.
What I'll try again.
No, you don't try again. Mr. Jain, just give me in 2 lines how you want to respond to Mr. Chaudhary.
My lord, before I trouble your lordship with whatever Mr. Chaudhary has submitted, if my lord kindly takes the notice invoking arbitration, Lord, whether there at all has been a section 21 notice. Possibly, my lord, then we'll all be saved with the trouble of troubling your lordship.
Which page?
Lord, yesterday, my lord, Mr. Chaudhary placed
367.
367.
my lord. 367, if lordship kindly.
366, my lord. I'm
366, sorry, my lord.
Yes.
366, my lord, there are 4 parties. My lord,
Yes.
Lord, my learned friend relied on this, treating this to be his notice under section 21. My lord sees the notice is addressed to 4.
Yes.
Notice is addressed to 4 persons. If my lord kindly turns to page 373.
Yes.
Lord, this is a track report. If my lord sees, this is track report of respondent number 1. My lord, 4th entry from the bottom, my lord will see addressee left without sufficient address. So no notice served upon respondent number 1. Now this is the 21 notice. Now if my lord kindly turns over
Yes.
to page 375, this is respondent number 2. Same fate. This address, this notice also not served upon respondent number 2. Then my lord, we turn to page 377. That's addressee number 3, my lord, in the notice. fifth entry from the bottom, Lordship will see item returned, addressee left without instructions. So as regards.
So what are they all leaving? Where are they leaving to or leaving
My lord,
from?
two of them are living in Allahabad. They knew that. They
No,
tried to serve. My learned
every endorsement says addressee left. Left means left
No,
where?
because, my lord, what had happened, their father used to live there. He passed away. And they knew that these two people, they are living in Allahabad, not in Calcutta. They had the addresses, but then they chose to serve respondent number 1 and 2 at
Very well. 377 is the third respondent.
377 is third. Fourth, my lord, for whom I am appearing, in fact, I am appearing for third and fourth both. So fourth has been served. So as regards, my lord, the notice invoking arbitration, section 21 notice of 20th of April 2023 has only been served upon one. My lord, it doesn't stop there. Possibly, my lord.
Only served upon 3, you mean?
Only 4. On 4.
On 4.
On 4. For whom I am appearing. 3 and 4, my lord, I am appearing.
Yes.
Now, my lord, possibly, my lord, Mr. Chaudhary forgot to bring it to my lord's attention. My lord kindly turns over to page 380, capital A, which is, this is another section 21 notice now, which is dated 4th of July. Today, Lordship is hearing an application under sections 11, subsection 6. Before my
Yes.
lord, 11.6 comes first, Lordship has to satisfy whether 11.5 has been complied on.
Yes.
Now, my lord, 380A. Lordship will see this is again notice under section 21, dated 4th July. Now, this is addressed to only 2 respondents. Who is my lord, Mr. Sengupta's client. This is not served upon me. So, my
So
lord,
30
in
days
law-
not gone.
No. So, my lord, this 4th July, I am not a party. Lordship will see. I am not a party to this.
So this is only 1 and 2.
1 and 2, Mr. Sengupta's client.
Yes.
So 3 and 4 are not even party to this. So, my lord, in law today, there is no section 21.
No. So what happened to 1 and 2? This and before 30 days gone, they filed the application.
So this I think they have filed after.
After.
But my lord, they are not referring. In fact, in pleading also, though this particular notice of 4th July is annexed to the petition, but it's not pleaded anywhere. So my learned friend's case is based out of.
Yes. Mr. Chaudhary.
28.
Then I don't have to deal with all this limitation.
No, Lord, I don't understand, Lord, page 381.
Yes.
Lord, 22nd May 2023 letter issued by advocate on behalf of 1, 2, 3 and 4. And this is a response to the first notice, 28th April notice, which is, my lord, page 360, 367.
This is in response to the first 21.
Yes. Lord, I believe there was an issue being raised regarding the Lucknow address, etc., Allahabad address. So, my lord, that had come up, I think, in the section 9, in the 11 also, which is why, by abundant caution, we issued another notice. But this is, my lord, please see, my lord, your purported notice dated 28th April 2023 under section 21 of the Arbitration Act issued by you on behalf of your client, US Intra, addressed to my clients. 1, 2, 3, 4. And there are 4 respondents. He's replied to the notice. Lord, I don't think it's possible for them to argue this. But before, my lord,
Mr. Both of you do something, please. Yes, I've understood. Now it's going to be the notice on the under 21, failing which the limitation. All right?
Yes.
Yes. Your quick reply to the notice, Mr. Jain,
My lord,
and limitation we will go to later on.
Lord, only just because, my lord, I have caused a reply through an advocate mentioning, my lord, that I am representing for, my lord, that does not mean, my lord, or imply that the notices have been served. Lordships have seen by their documents. The track reports evidently shows, my lord, that the notices have not been served upon respondent numbers 1, 2 and 3. Just merely, my lord, I say in my reply that, okay, I am referring, my lord, that does not mean that the notices have been served.
he's received the notice. He's given a reply.
I
And he
have
says just
Mr.
because
Chaudhary, no.
Sir, I'm
Has to
quite,
be served. Has
I'm-
to be served. Whatever the lawyer says, irrelevant. Has to be served. Your document has to show service. 21.
Yes, so my lord, 1 and 2 have received, and 3 and 4 have received the second.
All
notice.
parties to the arbitration agreement?
Yes. and
Second
everybody
notice,
is
second
received.
notice is piecemeal, doesn't address all the 4 respondents. All are parties to the arbitration agreement. How can you serve piecemeal? No,
No, I'm not serving piecemeal, my lord. Please see my notice.
No, no, no. Mr. Chaudhary, I'm against you on this point. On the limitation, you can, or rather I will have to hear Mr. Jain tomorrow. Yes, but I'm telling you, I'm against you on this point.
On
21
notice.
has to be clear service, no matter what the lawyer comes and writes.
No, but
Yes,
my lord, please see, my lord, page 381.
I've seen that.
I, my lord, I give a letter to my learned friend and it's addressed to 3 people. And my lord, assuming the other 2 people don't receive it by post, but they receive a copy from him, all 3 of them reply. None of them, my lord, can come and
All this is your spin doctoring on the advocate's letter. There's no evidence to it. Yes, tomorrow or day after?
Tomorrow.
Tomorrow, my lord. I'll, my lord, satisfy your lordship on notice. And there's also service, I'll satisfy your lordship. Now, this, after replying, it's not possible. You're stopped from contending that you haven't received the notice. I'll, my lord, show some.
Very well. Yes. Tomorrow? Or maybe day after. Yes,
If it's not inconvenient, my lord, if your lordship permits of not Friday, my lord.
Friday. It will be either Thursday or Monday. You
Then
can
Monday,
choose.
my lord.
Monday?
Oh,
Mr. Jain?
I'm very sorry, my lord. May it be the Tuesday, my lord.
Tuesday. Yes, Mr. Jain, Tuesday is all right with you? 26th?
26th, but only difficulty, my lord. Could it be on 20th then, subject to last?
20th?
28th, my lord. which is a
28th,
Thursday.
very well.
Lord,
What is
I-
it? Just agree on a date
But
also
I
of
leave
you.
it to your lordship, my lord. No, I leave it to your-
29th, my lord, day after.
No, not 29.
You want it in November?
No, the lordship will keep it on 26th. Lordship will keep it on 26th.
Yes, learned counsel appearing for the respondent has also taken the point of incomplete service of the section 21 of both the section 21 notices issued by the petitioner. Stop. Next, the point of delay. Counsel will continue to argue on the point of delay on 26 September 2023. Stop. List this matter on that date as prayed for. Stop.
Item number 14, square 4 assets, management and reconstruction.
Lord, item 14, my lord, I appear on behalf of the plaintiffs. Lord, Mr. Banerjee was addressing your lordships. Lord, he was supposed to address today. Lord, I've been told, Lord, may I pray for a short passover? Lord, if your lordships are, Lord, allowed.
Start your
Lord's
argument.
actions. Lords, before, my lord, I address your lordships on the points which have been placed by my learned senior friends. Lord, for the defendant number 3 and defendant number 8. Lord, may I only take your lordships through the frame of the
You want to take your opponents individually or together?
Lord, individual.
Individually.
Yes. Lord, before that, my lord, may I start only with the frame of the suit, my lord, because a lot of questions have been posed with regard to the frame of the suit, all parties not being made trustees. Lord, may I start with the plaintiffs, my lord? Lord, page 1, my lords.
Mr.
Yes.
Yes. Mr. Huck, what you do is first you just tell me what those points are
Yes.
taken by the respondents and then
Lord, I'll start with the defendant number 3, my lords. My lord, because a lot of points are common between the defendant number 8 and the defendant number 3. My lord, first point, all trustees have not been made parties to the suit. The suit is not maintainable due to non-joinder of parties.
given number 3 is sale
Is sale.
and 8 is Mr. Chakraborty's flat.
That's right.
Yes.
Lord, Mr. Mitra was addressing on behalf.
Yes, yes.
My lord, the second is the suit is not maintainable at the instance of the plaintiff number 1. No locus standi. Plaintiff number 1 has no locus standi since all trustees did not execute the lease in favor of the plaintiff number 1. My lord, that is the second point. My lord, third point, my lord, that is in line with section 47 and 48 of the Indian Trust Act, my lord, wherein my learned friends have contended that a trustee cannot delegate its functions of running and managing the trust estate. The plaint has been affirmed by a representative of the plaintiff number one. So therefore, my lord, since none of the trustees have affirmed the plaint, my lord, it is their contention that the suit is not maintainable at the instance of an outsider. My lord, essentially the principles of delegatus non potest delegate.
Yes.
My lord, the next one, my lords, my lord, is the authority to institute the suit by a trustee. That is question. Lord,
Yes.
only one trustees cannot act singly. Lord, that is section 48 of the Indian Trust Act. Lord, the next contention is with regard to Thika tenancy, which, Lord, in all fairness, it is only the defendant number 3 who has taken this point. Lord,
Yes.
defendant number 8 has not really urged this point, but I'll have to deal with it because it is a part of their pleadings in the affidavit in opposition to the GA 1835, which has been filed. Lord, in addition thereto, Mr. Mitro, learned senior counsel, Mr. Mitro, he had taken the point that there is no privity of contract between the plaintiffs and the defendant number 3, since the defendant number 3 is an assignee of the defendant number 1, who was the original lessee in respect of the earlier deed of lease, which is of 1965. Lord, so there, yes, Lord, I'm very grateful to my learned friend. Lord, this is the order which your lordship had passed on the last occasion recording the submissions. Lord, may I hand up?
Submissions?
Submissions of the defendant number 3. Lord, I was to, of the defendant number 8. Lord, I have to address on these issues, Lord, but I've Lord, also covered the points which are there in the affidavit in opposition.
Yes, yes. So apart from that, Mr. Dutt's client took the point of the Thika tenancy. Apart
That's-
from these.
Yes, ma'am.
And any other point which remains?
My lord, apart from that, it has always also been a contention of my learned senior friend that they are a tenant, my lord, tenant under the West Bengal Premises Tenancy Act. My lord, submissions have been advanced. My lord, I shall deal with that as well. My lord, so, my lord, in that regard, my lord, may I only start off first, my lord, with the frame of the suit, because my lord, that would assume significance, because a lot of questions on the trustees not being authorized to institute the suit. Lord, may I start with the frame of the suit? Lord, page 1, Lord, the cause title. Lord, the first plaintiff, Lord, if your lordships has it, is
Page 1 of GA.
Page 1 of GA 1835 of
Yes.
2016. Lord, the
Yes.
first plaintiff is Square 4 Assets Management and Reconstruction Company Private Limited. Lord, this is the present lessee in respect of the premises. Lord,
Yes.
there is a lease which has been executed by the trustees in favor of the plaintiff number 1. Lord, that lease is dated, Lord, 12th September 2015.
Yes.
Lord, the second and the third trustees were the original trustees who were plaintiffs in the suit. Lord, there was a point taken that one of the trustees were not made parties. Lord, that trustee, Lord, I shall indicate, is Mr. Purnendra Mallik, who was not a party. Admittedly, Lord, there's no dispute with regard to that. My lord, it is their contention that he also had to be made a party along with one, Mr. Rupendra Mallik. My lord, we had filed an amendment application, my lord, which was numbered as GA 3121 of 2016. My lord, that was eventually dismissed by the trial court, holding that the suit is non-est. My lord, thereafter we had applied before the appeal court. My lord, the Honorable Division Bench, by its order dated 23rd December 2019, was pleased to allow the amendment.
Mr. Huck, didn't Mr. Mitro take a point that the plaint was amended, but not the petition or something like
Yes,
that?
my lords, yes, my lord, that is also a point. It's also captured, my lord, in the order. My lord, I shall deal with that also. My lord, but my lord, what is important in so far as the order of 23rd December 2019 is concerned, is that the objection with regard to all trustees not being made parties to the suit, my lord, in my most respectful submission, has been waived. My lord, why waived? My lord, I shall only show a copy of the order. My lord, may I place that order of 23rd December 2019 in order to, my lord, show that, my lord, my learned friends themselves had contended that they do not have any objection if the amendment is carried out in the suit. Lords, may I? Lords?
No, they, sorry, they don't, very well, let me read.
Lords. Lords, there in the compilation of the
Give a
Lord, the
copy
judge.
to Mr. Dutt, please.
Yes, ma'am.
Which page are you relying on, Mr. Haq?
My lord, it is at page 80 of the compilation which has.
Page 80, এটা তাহলে ওনাকে দিও।
My lord, page 80.
Compilation you've given.
My lord, the compilation submitted by the defendant number 3, the compilation of judgments.
Yes. Page 80.
My lord, page 80. My lord, that's the order dated 23rd December 2019.
Yes.
My lord, straight away, my lords, may I take your lordship through, my lord, page 82. My lord, that is where, my lord, the contentions are recorded and the fact that the defendants do not have any objection. My lord, may I read from paragraph 3 onwards, my lords?
Yes.
My lord, it says, the principal contention of the appellants is that since there may not be any question of limitation, the failure to implead all the trustees should not be deemed to be fatal to this action, and the other trustees could be added as co-plaintiffs for this suit to be pursued. The appellant submitted that an appropriate amendment application was duly filed. My lord, this is the application 3121. My lords, thereafter, my lords, some of the defendants say that in view of the fact that the institution of a fresh suit will only lead to the multiplicity of
No,
proceedings.
1 minute. What did you say? This is the application 3121 means what?
My lord, the application, the appellant submit, my lord, the last line of the third
Yes,
paragraph.
is that I know, but this is the application means?
My lord, which was dismissed by the trial court after challenging that order. My lord, we had come before the honorable division bench. And my
Right.
lord, that is what is recorded. The appellant submit that
Yes,
an
yes.
appropriate. My lord,
Yes.
some of the defendants say that in view of the fact that the institution of the fresh suit will only lead to multiplicity of proceedings, they are agreeable to accept the proposed amendment for the original and the newly added plaintiffs to carry on the action.
Yes.
But they say that the application under chapter 13A of the rules on the original side of this court must be abandoned by the plaintiffs. It is submitted by the appearing defendants that the very basis of the first plaintiff being a party to the action and the purported rights claimed by the first plaintiff are in doubt, since only 3 of the trustees executed the subsequent lease in favor of the first plaintiff, and no property could have passed without all the trustees simultaneously executing the document. Lord, so, Lord, if I may, my lords, only indicate, Lord, that this proposed amendment was actually it was agreed to by the defendants. My lord, my learned friends, my lord, for the defendant numbers 3 and the defendant number 8 were duly represented. They did not have any objection with regard to the trustees coming on board. The only objection, my lord, in my most respectful submission, which is that the lease which has been executed in favor of the plaintiff number 1 was called into question. Why? Because it was executed by only 3 out of the 4 trustees. My lord, that is what, my lord, I shall endeavor to satisfy your lordship that that is not an act which would have the effect of rendering the lease void or ab initio, or the plaintiff not having any right to institute the suit. My lord, but insofar as the trustees being added, my lord, that has been accepted by my learned friends. My lord, only insofar as that is concerned, my lord, permit me to place the next page also. My lord, page 83, this is what the learned division bench holds. My lord, my lord, may I read? My lord, page 83. To avoid any controversy, the plaintiffs, including the proposed added plaintiffs, have agreed that they will not pursue any application under chapter 13A of the said rules in the suit as long as the amendment is allowed and the suit is expedited. Lord, we have not pursued the chapter 13A. We have abandoned it insofar as the defendant number 3 is concerned, and also the defendant number 8. Lord, that was a condition. We accepted that, Lord, and we filed the amendment. So therefore, my lord, my submission insofar as the first question, my lord, the first submission of my learned friends is that the suit is not maintainable at the behest of some of the trustees. My lord, when admittedly all the trustees as on date have been added as parties, is perhaps cannot be countenanced at this stage. My lord, in that, my lord also kindly appreciates the fact that, my lord, right now, my lord, may I also now come back to the frame of the suit. My lord,
Frame of the suit, that's the same argument.
yeah, my lord, the frame of the suit only to show who are the trustees who were parties and who are the trustees who have now been made parties.
Yes.
My lord,
For that you was showing me page 1.
Page 1, my lord, page 1. My lord, Deependra Mallik and Hirendra Mallik were the original trustees. The one who was not impleaded was Purnendra Mallik, who passed away, my lord, 4 days prior to the institution of the suit. So he was not made a party. The other trustee, my lord, admittedly, Mr. Rupendra Mallik, he resides in the UK. My lord, he, of course, my lord, subsequently, my lord, those documents are not here. My lord, it forms a part of the record of the suit. but they are not here before your lordship right now. My lord, GA 3121, Rupendra Mallik had consented to the suit being filed.
GA 3121, the one which
Of
was dismissed.
2016, which was dismissed, the amendment application, we
Yes,
had filed supplementary affidavits in that as well. My lord, the other two trustees, my lord, Purnendra has two heirs who have now been brought on record. Rupendra Mallik has passed away issueless. My lord, Purnendra Mallik's two sons are Shuvendra and Topendra. My lord, that has been incorporated in the amended plain. My lord,
Yes.
if your lordships have the amended plain, my lords.
Mr. Haq,
I
you can
have a copy.
continue till the
Yes.
way, till
Yes,
the document is brought out.
My lords, there is, my lord, now there are a total of 4 trustees and the plaintiff number 1, which is the current lessee. My lord, the 4 trustees are Deependra Mallik, plaintiff number
I remember all Malliks.
My lord, the other 2 are Topendra and Shuvendra. So, my lord, there are 4, total of
Yes.
4 trustees as on date. So, my lord, this objection after the trustees have been impleaded, my lord, I've shown your lordship the order as well, my lord, which clearly shows they did not have any objection that the trustees be brought on record.
Yes.
My lord, the only objection is with regard to the execution of the lease in my favor, my lord, which has been captured in the order of the division bench, my lord, which, my lord, I shall try to satisfy your lordship that this is not, my lord, this is not a case that this was done without the consent and concurrence of the trustee who's not signed the document. My lord, in that regard, my lord, may I place reliance, my lord, on the lease deed dated 12th September 2015. My lord, that is at page 256 of the GA number 1835 of 2016, which is before your lordship.
Mr. Haq, how many volumes do I have to navigate
Look,
through?
there is
to find?
only one.
No, I'm not complaining. I'm just asking you.
Only one.
Only one?
Yes. Lord, page 256
Yes.
is the deed which has been executed in my favor. Lord,
Yes.
the plaintiff number 1 by the trustees. Lords, I shall take your lordship through the formative part of the lease, my lords. Your lordship will
No,
find.
that you will do on the next day. Just tell me what your argument will be.
My lord, only one clause which I want to show your lordship, that is clause, my lord, that is at page 271. My lord, my lord, 3 out of the 4 trustees have executed this document.
Yes.
Page 271, my lord, paragraph I.
Yes.
My lord, my lord, may I read, my lords? There is another trustee, namely Shri Rupendra Mallik, son of Ruthindra Mallik, who is now in the United Kingdom. And since he will not be able to remain present at the time of execution and registration of this deed of lease, he has duly given his consent.
Yes, I've read it.
Lords, and thereafter, my lords,
And
also
Purnendra Mallik is the one who died.
Purnendra Mallik is the one who died. My lord, but he's a signatory to this deed of lease.
Yes.
My lord, also, my lord, J is very important because, my lord, 3 of the trustees, they say, have full power and unfettered authority to grant this lease in respect of the demise premises in favor of the lessee here.
Very well. Thank you, Mr. Haq. Tell me when you want to come back.
Lords,
And what will help me, Mr. Haq, when you make your submissions, just tell me what the objection is, raised by who, and then your response to it.
I'm great.
But otherwise, you've argued well.
I'm great.
Tell me when.
Lord,
you want
tomorrow,
to-
my lords, tomorrow is convenient to your lordship.
Learned counsel appearing for the petitioner. The petitioners will continue with his arguments. I'm putting it on 21st, all right? On 21st September 2023.
Great.
Follow the next matter, please.
Item number 15, Vimal Chandra Roy. Item number 15, Vimal Chandra Roy.
This is second consecutive date when no one appears for the petitioner. Stop. AB 364 of 2023 is accordingly dismissed for default. Stop. Interim orders of any shall stand vacated.
Item number 16, Marine Industrial Infrastructure Private Limited.
I'm appearing on behalf of the petitioner, your lordship.
Yes.
And Mr. Rajoshi Doctor in this matter, your lordship. May I file the affidavit of service, your lordship?
Yes.
Your lordship, this section 29A application was previously served on the advocate on record appearing for the respondent in the arbitration, your lordship. Subsequently, they had returned the petition stating that they did not get any instruction from the respondent. Subsequent and thereafter, we had served on the respondent, which they had received on the 11th of this month, your lordship. Your lordship, the section 11 order was.
So where have you filed your affidavit of service?
Yes, your lordship, there are two affidavits of service to that
Yes.
effect, your lordship. The section 11 order was passed on 28th January 2021, your lordship, which is at page 13, annexure A.
Page 13.
Yes, your lordship.
Section 11 order is not material for section
Okay.
29A.
Very well, your lordship. The rejoinder, your lordship, there is a counterclaim in this arbitral proceeding, and hence the rejoinder which was filed by us was on 1st February 2022, your lordship, which is at page 33.
1st February 2022.
Yes, your lordship.
Yes.
Page 33, your lordship. And thereafter,
The rejoinder in the counterclaim.
yes.
You are the
rejoinder-
respondent.
Yes, I'm the claimant, your lordship. I'm the
Yes.
claimant.
No, but does 23(4) say that?
Your lordship, the 23(4) says that 6 months for the statement of claim and the counter statement, your lordship. But in since there is a counterclaim in this proceeding, the filing of an opposition to that counterclaim becomes.
No, says completion 12 months from the completion of pleadings under section 23(4).
Yes, your lordship,
That's
that
what
it does.
29A says.
Yes, your lordship, that it does. That it does.
Then
Your lordship, all I'm trying to impress is that since I'll just. The statement of 23(4), the statement of claim and defense under this section shall be completed within a period of 6 months from the date of the arbitrator or all the arbitrators as case may be received notice in writing of their
Yes.
appointment, your lordship. All I'm trying to say is that the statement of claim and the defense, your lordship, that was filed, but along with the defense came a counterclaim to this proceeding.
yes.
Hence, there was time required to file for the rejoinder. Hence, I'm trying to impress upon your lordship that the period of 12 months will begin after I file the rejoinder, because that will be taken as a.
Not rejoinder, your reply to the
Yeah.
counterclaim.
Yes, your
Why are you
lordship.
saying rejoinder? When did you file the reply?
Your lordship, on 1st February 2022,
Very
page
well.
33, your
So
lordship.
12 months from that date.
Yes, your lordship.
Yes.
And that came to an end, your lordship. The section 29A3 extension is from 1st February 2023, your lordship,
Yes.
which is recorded in the 19th minutes of meeting at page 34, your
Very well.
lordship.
So 6 months.
Your lordship. Now, if we go by that
So 1st August. 1st August 2023.
31st July, your lordship. I would
31st
say.
July.
Now,
Yes.
your lordship, that application has been filed after that. But now your lordship kindly considers by the Honorable Supreme Court's judgment on the suspension of limitation, the limitation was suspended till the 28th of February 2022, your lordship.
Yes.
Now, under such circumstances, if we calculate the 1 year from after 28th of February, your lordship, from the 1st March, then the first year, 12 months, come to an end by 28th of February 2023.
Yes.
And thereafter, the 6 months consent which was given by both the parties, your lordship, then it comes to an end on 30th August.
And the application which has been filed is before that, before such date, your lordship.
What before? Application is also filed on 30th August.
Yes, your lordship, the last day.
Yes, so that, why are you saying before?
I apologize.
Yes, what about the respondents? Why are they not appearing?
Your lordship, we have served on them. Previously, we had served on
Show me the actual service.
Yes, your lordship. Both, there are two affidavits of service, your lordship. The one which I filed today will show the service on the respondent on 11th of this month.
What is the stage of the agreement, arbitration?
Your lordship, the respondent's witness is being examined, your lordship. They firstly brought in one witness, which has abandoned while he was being cross-examined. Thereafter, they had brought in further witness who has been also completely cross-examined. Now they propose to bring another witness, your lordship. Which
Your witness is done.
Yes, your lordship. Your lordship.
And where is Justice Chakraborty's order?
Page
Which page?
13.
13. When did the proceedings start?
Your lordship, the first sitting took place on 8th March 2021, and the arbitrator entered upon reference on 1st March 2021. 1st March is the entry upon
Yes,
reference.
the affidavits of service show that the respondent was served twice, but has, however, failed to be represented. Stop. The last service shows, the last service was made on 11th September 2023. Stop. Next. The petitioner seeks extension of the mandate of the learned arbitrator who was appointed by a learned single judge of this court, comma, as his lordship then was, comma, on 13th January 2021. Stop.
28th January 2021.
28th January 2021. Stop. The arbitrator entered reference on 1st March 2021. Stop. Next, learned counsel appearing for the petitioner seeks to take advantage of the Supreme Court orders extending periods of limitation in the wake of the pandemic and say that the 12 months under section 29A within brackets 1 of the 1996 Act will be counted on and from 1st March 2022. Stop. The parties consented to an extension of 6 more months under section 29A within brackets 3. Stop. The two periods taken together would be 30th August 2023. Would end on 30th August 2023. Stop. The present application was filed on that very date, i.e. 30th August 2023. Stop. The counsel further says that the respondent's witness is presently being cross-examined, and that the parties will commence their respective arguments soon after witness action is over. Soon after the witness action is over. Witness-action is over. Stop. Next, considering the fact that the arbitration started from 8th March 2021. Is it 8th or 1st?
8th March.
8th March 2020. Considering the fact that the first sitting was held on 8th March 2021, And almost 2.5 years have gone since then, comma. AP 641 of 2023 is accordingly allowed and disposed of by extending the mandate of the learned arbitrator by 6 months from 30th August, by 7 months from 30th August 2023.
Your Lordship, may I pray for a little more time? Because in this, in the interagnum, Your Lordship.
No, call on the next matter, please.
Lordship, the next two applications are analogous. It's having the same date, Your Lordship.
No, so I can pass one order in all
Same, no, yes, same orders.
17 and 18.
combined order. Combined order.
Same dates.
No, alada order. Yes, call on the next matter, please. Same order. Alada order. Next.
Same.
Same order.
Item number 19, Bethwaite and Co.
I'm appearing for the petitioner.
I beg to appear for the respondent, my lord.
Yes.
I filed the affidavit of service.
I can't hear you. Microphone, please.
My affidavit of service. my lord.
Yes.
There is an application under section 29A subsection 4, my lord, for extension of further time of 6 months. My lord. My lord, the period.
I can't hear you. Microphone,
My lord, the
please.
period. My lord, the period for the arbitral reference, my lord, the mandate is expiring on 22nd of September 2023, my lord. The application has been filed on 14th of September,
How does it extend till 22nd September?
my lord. My lord, kindly sees page 32, my lord, running page 36, annexure C, my lord. The completion of pleadings, my lord. The completion of pleadings, my lord, had occurred on 22nd of March 2022. Well,
Yes.
subsequent, my lord, in view of the judgment passed by the Honorable Supreme Court in the Somoto case 3, my lord, with regard to the COVID-19 pandemic, my lord, the 1-year period, my lord, ended on 22nd of March 2023.
Why 22nd March 2023? It will be counted from 1st March 2023.
But the pleadings, my lord, were concluded on 22nd March 2022, my lord.
Yes.
My lord, I apologize. It will start from 1st of March, my lord. 1st of March 2023, my lord. My lord, subsequently, my lord, the parties had consented to a further extension, my lord, on 6th of August 2022, my lord.
6th August.
Yes, my lord. To be on the safer side, my lord, the honorable arbitrator, my lord, had recorded that to be on the safer side, it will be a further
It
extension.
has to start from 1st March or 2nd March. Your pleadings completed and then 6 months will start thereafter, soon from that same day. How can it be 6th August?
My lord, due to the operation of the judgment, my lord, we are taking advantage of that.
Can't you understand that? I've
Yes, my
understood.
lord.
12 months will end on 1st March 2023. When was the consent taken?
The consent was given, my lord, on 6th of August 2022.
6th August 2022
22, my lord.
for 6 months.
Yes, my lord.
So that
My lord,
consent
that was a
will,
prior consent, my lord.
very
given
well.
by
So
the parties.
consent will be 1st March plus 6 months.
My.
So when is that period ending?
My lord, the period is ending on 22nd of September, my lord.
From 1st March, 6 months, how can it be September, 22nd September? You should have calculated all this and then come to the court.
My lord, it was calculated, my lord. It is as per the directions, my lord. My lord,
From
the
1st March,
calculations,
6 months will take you to September,
my lord, it will take me to October, my lord.
October. What do you say?
From March to,
My lord, the pleading was completed on 22nd March. And from there, my lord, the first 6 months will be on September only, my lord. 22nd.
Which date in September? Neither of the parties are ready with the matter. Neither of counsel appearing for the parties are ready with the matter. Stop. They should have been prepared, at least with the dates, relevant dates. Stop. List this matter tomorrow. Next.
Very good. I shall come back. Great.
New chamber application. Item number 59, Jaspal Singh Chandu. I appear for the decree holder, my lord. This is a decree passed by this honorable court, my lord, in a eviction suit. Now, my lord, this is a consent decree. Now, my lord, pursuant to an order by my lord coordinate bench of 13th of July 2023, my lord, the receiver was appointed to take symbolic possession, my lord, of the asset in the premises in question.
Yes, now you want actual possession.
Yes. Now, my lord, that is being resisted. I do not understand how, because I want to show the consent decree and there is no appeal or order 9 rule 13 against this decree, my lord, saying that this decree is nullified or this decree does not stand as of today. Now, my lord, if your lordship sees the decree, my lord.
Yes.
So the decree is on consent terms, and my lord, in the consent terms, it starts from page 11. My lord will kindly come to, my lord, page 19. My lord, the decree was in two parts. One is that, my lord, he would stay there for a period of time by paying a rent amount. And then after the period is over, he used to vacate it. Now, my lord, in the meantime, if during the period of 10 years, if he defaults, then, my lord, I will put the decree for execution and he has to vacate the premises. That's the consent decree passed by this court.
Where is page 19?
Page 19, if your lordship comes.
14 is the last page of the decree.
Lordship, a typed copy is at page 28. Your lordship can take that also. The terms of settlement starts at page 28. It's
28. Yes.
Now, my lord, even lordship will kindly come to, my lord, page 30 then. Paragraph 4. It is agreed by the parties that the monthly rent of the said premises shall be 2,000 payable according to English calendar month by the defendant to the plaintiff landlord. Now, my lord, this is the rent he is supposed to pay. Now, what happens if he does not, my lord? Kindly comes to page 32 of the typed copy, paragraph 9. The name and style and status of the tenancy shall remain as GC Seal and Company. This is very important, my lord. As proprietorship firm of the defendant Govindo Chando Sheel as usual. And the same will be continued for a period of 10 years. That is from the date of the decree, my lord, without any alteration and or amendment. It is agreed and made clear that the said tenancy will not be terminated prior to the stipulated period of 10 years, provided the terms and conditions as stipulated herein and also the grounds as provided in West Bengal Premises Tenancy Act 1997 are complied with strictly by tenant defendant. It is agreed that at the expiry of 10 years from the date of these terms of settlement, the defendant shall hand over peaceful vacant possession of the demised premises to the plaintiff and or his successors in interest and or default thereof, or in case of any other default by the defendant, the plaintiff and his successor in interest will be entitled to execute the decree to be drawn up herein and seek recovery.
What is the default, Mr.
My lord,
Banerjee?
the default is that till 2020, my lord, he has paid the rent. Thereafter,
decree is dated?
My lord, the decree is dated, my lord, 23rd of June 2014.
21st June.
23rd of June 2014.
Yes.
Now, my lord, the default is that, my lord, from 2020, he is not paying the rent. Now, my lord, his case is that, in his opposition, is that, my lord, I have tendered the rent, you have not accepted it, therefore, I have filed an application before the rent controller and deposited it. Now, my lord, kindly sees, my lord, who is tendering the rent. That is why, my lord, from the decree, I read out that portion that there cannot be any parting of possession, and GC Seal and Company, the defendant Govindo Chando Seal is to continue. Nobody else, my lord, can go in there. And if it is done so, then the decree records that, my lord, that would be terminated because it would be taken as a parting of possession of the property. That is paragraph 9. Now, my lord, what is happening is that one gentleman whose name, my lord, is my lord Shubhashish Nondi, kindly takes any of the rent control forms he has enclosed with the opposition, page 68, for instance, my lord, of his opposition. One Shubhashish Nondi is acting on his behalf. Not only that, my lord, kindly will see that, my lord, the department.
Mr. Banerjee, just 1 minute. Let me understand this, please.
Yes, my lord.
That the status of the tenancy will remain as GC Seal.
Yes, my lord.
And
company.
yes, as a proprietary firm,
Yes, my lord.
and will be continued in this way for 10 years.
10 years.
10 years from the date of the decree.
Yes, that is till 2024. He is supposed to stay there and then give it back to me.
Without any alteration or amendment.
Yes.
And that tenancy will not be terminated prior to the, what is the stipulated period? 10 years.
10 years stipulated period. Yes.
And you're saying that it has not been kept as a proprietary firm of GC Seal.
Yes, there is a parting of, my lord, the tenancy, which is recorded here. Lordship will kindly see, my lord, without any alteration amendment, it is agreed and made clear that the said tenancy shall not be terminated prior to the stipulated period of 10 years and conditions as stipulated herein and under the grounds of West Bengal Premises Tenancy Act. Now, my lord, under the West Bengal Premises Tenancy Act, if there is a parting of possession, I am entitled to an eviction. That is also recorded. Lordship will kindly see at the bottom of that paragraph, my lord, the court records in the consent decree. My lord, if I may read, my lord, it is agreed that at the expiry of the 10 years from the date of these terms of settlement, the defendant shall hand over peaceful possession of the demised premises to the plaintiff and or its successors in interest and or default thereof, or in case of any other default. That's very important, my lord. By the defendant, the plaintiff and his successor in interest will be entitled to execute the decree to be drawn up herein and seek recovery of vacant possession. Now, from 2020, my lord, he is not being paying the rent. So, my lord, when I file this execution, my lord, he makes out a case that I have been paying I have offered to you, you have refused, and that is why, my lord, I have paid, I am paying it to the rent controller. Now, my lord, kindly takes any of his, my lord, the documents which he has enclosed, kindly sees, my lord, who is offering and, my lord, why should I accept it? My lord, kindly takes the application which he has filed before the rent controller, which is at page 55 of his opposition.
So, Mr. Banerjee, you want
Possession.
Possession now on the
Yes,
basis
in terms
his
of the
default.
decree. In terms of
on
the
the basis
decree.
of his default.
Consent decree. Yes, my lord, on the basis of the default. Now,
Yes.
my lord, if your lordship sees this application before the rent controller at Calcutta at page 55, which is his best case, my lord will kindly come to page 57. It's been affirmed by Shubhashish Nondi, employee and agent of applicant's firm. Admittedly, my lord, not the person in terms of the decree. Shubhashish Nondi, nobody knows him. I don't know him.
No,
Employee.
applicant's firm is what?
My lord, GC Seal, and that is what he is trying to impose. But my lord, there is no document, nothing at all. One Shubhashish Nondi is filing this. Now, kindly sees, my lord, who is, my lord, putting in the money also in the rent controller at page 58. Lordship will find, my lord, the signatures are all, my lord, if I may show one page where it is absolutely clear, is, my lord, page 68, lordship takes, my lord. It is Shubhashish Nondi. Yes, my lord. Kindly takes the rent control form number 3 at page 68.
Yes.
My lord, towards the
Yes,
middle,
yes, I've seen it.
it is Shubhashish Nondi, and my lord, the date of this receipt. my lord, if I even take by the stamp that is there, my lord, it's sometime in 24th of December 2021. So admittedly, it is the period that I am, my lord, complaining of. My lord, the date is at the bottom, 31st of December 2021. That's the period, my lord, I am saying that I have not received rent. So therefore, my case is that, my lord, one, I am not supposed to recognize Shubhashish Nondi. It's a parting of possession.
What is wrong with the name?
My lord, Shubhashish Nondi is not the proprietor. As I read from the decree itself, it records the proprietor is Govindo Chandoshil. And my lord, that case is not made out here, that my lord, Govindo Chandoshil is no longer alive, or that Shubhashish Nondi is, my lord, his successor, or that, my lord, Shubhashish Nondi has been given the right to perform or, my lord, proceed in his favor. Neither of these three instances are being, my lord, the case made out in his opposition. None of these cases are there. So, my lord, even if he says today that the section 7.1 application before the, my lord, premises tenancy tribunal was filed by Shubhashish Nondi on the basis of, my lord, power of attorney given to him, that is also not enclosed in this opposition. So, my lord, prima facie, my lord, it is established that this Shubhashish Nondi is a third character and there is a third party right being created over the property. And that's exactly what is being restrained by the consent decree. So, in view of that, my lord, I, my lord, seek, my lord, that the receiver should be appointed because we are, my lord, in execution. Obviously, my lord, I have to take possession of the asset. So, receiver has to be appointed at least to safeguard, my lord, the my lord, property from third party rights being created. Because tomorrow, my lord, it is obvious that Mr. Shubhashish Nondi might file a, my lord, a case before, my lord, the court below, my lord, against me, saying that I am a tenant or even I am a trespasser and I cannot be evicted without due course of law. Because there would be a right created in his favor. So, my lord, then, my lord, even if I have this decree today, I have to go and fight, my lord, against Shubhashish Nondi to, my lord, have a decree against him to put him out of the property, which I am not, my lord, supposed to in view of this decree. Because the decree is very clear. If there is any parting, he has to immediately, Mr. Sheel has to immediately give the possession to me. So, my lord, from his document, it is clear that there is a parting and there is no document saying any authorization. There cannot be any authorization.
Parting in the form of that Nondi person's.
Yes, yes. Yes, my lord. Had it been even been filed by Mr. Seal before the, my lord, rent controller at Calcutta, I would have understood. I would have understood because there was prior a default made by them and Justice Shomenchen passed an order that similar circumstances arose. Lordship will find, my lord, in this order. There was an execution filed prior also in this matter. This happened and, my lord, Justice Sen had, my lord, at the second page has recorded. There is nothing on record to show that the decree holder had refused to accept the area's monthly rent. Because then also I said that, my lord, why should I accept it from somebody else and create a right over the property? Of the order, in absence of documents, deposits made with the rent controller are invalid deposits. So therefore, all deposits made by him, including the application, my lord, is, my lord, not against me. I should not even look into it. Neither the court should look into it. Because Mr. Nondi is not before this court.
Yes.
So, my lord, in view of that, at the present stage, my lord, I am seeking, my lord, that the receiver already appointed by the, my lord, coordinate bench, my lord, be directed to take physical possession. Because otherwise the asset, my lord, rights would be created. And, my lord, it would only lead to, my lord, litigations being filed before other courts, my lord.
Mr. Kaur, your just your 2-3 line submission to that, and then we can hear you later.
Lordship, the only
Microphone, please.
Lordship, the only allegation is that the rent has not been paid. It can be sorted out. The rent can be tendered and paid. There is no dispute as far as that. As far as the rent is concerned, it has been deposited by an employee. Lordship will kindly take the definition of tenant under the West Bengal Premises Tenancy Act. It is not in dispute that the tenancy is covered by the West Bengal Premises Tenancy. The compromise decree also records that. Kindly take the definition of tenant. Lordship will kindly take section 2G. The Lordship will find section 2G.
Yes.
Tenant means any person by whom or on whose account
or behalf, the rent of any premises is or but for a special contract would be payable and includes any person continuing possession after the remission. So Lordship, anybody on behalf of the tenant could also be paying rent. Lordship, pausing here for a moment. Now kindly take the affidavit in opposition and kindly take the application which has been filed under section 21 to deposit the rent. Your Lordship will find that affirmation at page 57.
Affidavit in opposition.
Yes, my lord. Lordship, the application starts at page 55. Kindly will come to page 57. It has been affirmed by Mr. Nondi.
Yes.
Your Lordship will find page 57. I, Shubhashish Nondi, the employee and agent of the applicant's firm, do hereby declare and state that the statesman
No,
may.
just one, please. Affidavit in opposition, that's okay. This is the one by,
Yes, my learned friend has been referring that somebody else is coming and
no,
paying.
no. This affidavit in opposition affirmed by
Lordship, by the decree holder. It's been a
Go-
judgment
yes.
that, I'm sorry, my lord, by Sri Govinda Chandoshil.
Very well. Yes, and page 55 of that.
Yes, my lord.
That is an application on, yes, 21.
Under section 21 of the
Yes,
West Bengal
yes,
Premises
yes.
Tenancy Act, the rent
Yes.
is being tendered.
Yes.
Your Lordship will find at page 57 the affirmation.
Yes, I've seen that.
Categoric statement that an employee, who is he signing on behalf of? Your Lordship will take page 55. He's signing on behalf of Messrs. GC Seal and Company, the proprietorship concern. Your Lordship will kindly take paragraph 1 of it. My learned friend has been relying on this document. Kindly take paragraph 1. Applicant's firm is a monthly tenant represented by its sole proprietor, Govindra Chandrashil. Categoric statement that Govindra Chandrashil is the proprietor. I am not the proprietor. I am only signing. Govindra Chandrashil, my lord, is 85 years old, as will appear from the affidavit. He has affirmed it himself. He's 85 years old. He's not always able to come out of the house. That's the only reason he needed an employee to come and affirm this affidavit. Lordship, pausing here for a moment. My learned friend is taking this as an excuse that it's been tendered by somebody else. Kindly let my learned friend show how the check amount was tendered. The check amount is drawn on the company account. It is signed by Mr. Govindra Chandrashil and not by anybody else. So this is where the amount is being tendered. He refuses it. Then we have to go under section 21. Your Lordship will kindly take section 21 also of the Act. It is only when the amount is refused that we come before. Your Lordship will, has your Lordship found section 21?
Yes. Yes.
Lordship, this is the protection given to the tenant where the landlord refuses to accept the rent. Where the landlord does not accept any rent tendered by the tenant within the prescribed period, the tenant shall remit the rent to the landlord by postal money order within 15 days of such refusal. This is what has been done. Where any tenant remits rent to the rent counter by postal money order within the prescribed period and it is returned to the tenant by the postal authority as undelivered, either on account of the landlord having refused to accept the payment thereof or for any other reason, the tenant may deposit such rent with the controller within 15 days. This has been complied with. We have only taken recourse to a statutory remedy available to the tenant under the West Bengal Premises Tenancy Act. Lordship, also another argument would be, my learned friend says that creation of an agent is creating a third-party right. Kindly take the Contract Act. Lordship will kindly take Contract Act sections 226 and 230.
Mr. Dashgupta, you can either yawn or you can look at your mobile phone. Not together. Section 230.
226 to 230, my lord. This is effect of agency on contracts with third persons.
Yes.
Lordship will find 226 contracts entered into through an agent and obligations arising from acts done by an agent may be enforced in the same manner and will have the same consequences as if the contracts had been entered into the acts done by the principal in person. He acts on behalf of the principal. He doesn't get any personal right. Lordship, there are two judgments I will cite on this. Lordship, one is 2016, Volume 3, SCC 296. The other one is 2012, Volume 1, SCC 656.
Mr. Kaur, tomorrow, you can give the citations to Mr. Banerjee.
Great.
All right.
Okay.
এগুলো কি new chamber? মঙ্গলবার দিন হবে তো। Yes, learned counsel appearing for the decree holder seeks to put the decree in execution by reason of the alleged defaults on the part of the judgment debtor within the period mentioned in the consent decree. Stop. Next, list this matter on 26th September 2023 for learned counsel appearing for the judgment debtor to continue with his submissions. Stop. If it is a consent decree, then are you the judgment debtor?
Yes.
You are. এই বইটা ফেরত দিন। আর একটা বই নিয়ে আসবে আগে। ওই flags গুলো বার করে দিন।
Only one more indulgence, that the receiver should not take any act because reliefs in terms of prayer A has been allowed.
Mr. Kaur, I am hearing the matter. How can the receiver act without my passing an order on the application?
The only thing, my lord, may it be on 28th, my lord, Lordship also takes it up on Thursdays.
28th, as
Great.
paid for.
Great.
Yes. ওই এটা তো আমি ফ্ল্যাগ করে দিও। Yes, call on the next matter, please.
Item number 60, IGE India Private.
This is my execution application
Yes,
in respect of a decree passed for recovery of possession of the suit premises.
I can't hear you. Microphone, please.
Recovery of possession of the suit premises as also for recovering area occupation charges. Now,
Yes.
There was previously on an application for judgment upon admission.
Yes.
A learned judge of the High Court granted me decree for possession because the lease period had expired, and also part of the occupation charges. The balance was relegated to the suit. which
Where
was
is
pending.
your respondent? Where is the judgment debtor?
I have not, this is first time.
First time?
Yes, but within 2 years, but I'll serve and come back. If your lordship.
2
so
years. What
please,
is the date of the decree you said?
Date of the decree is 17 February 2023. But if it comments to your lordship, I am praying for prayer A and B, affidavit of assets, and the first prayer is not restraining him from alienating that money from his bank accounts. If your it's comments to your lordship.
No, I will give you affidavit of assets.
Very. And I'll give him a notice, let him come.
Yes, a learned counsel appearing for the decree holder seeks execution of a decree dated 17th February 2023. Is it an award or a decree? Decree. 17th February 2023. Stop. Since decree is less than 2 years. Now, since less than 2 years have elapsed from the decree, comma, let a copy of the application be served on the judgment debtor. Stop. There shall be Where is your prayer for affidavit of assets?
Prayer B, prayer B.
There shall, in the meantime, be an order in terms of prayer B of the tabular statement, which is a direction on the judgment debtor or director/persons in control of the judgment debtor to file their respective affidavits of assets within, what is a good time?
As your lordship pleases.
Within 6 weeks from date, stop. List this matter. After list this matter on 30th November 2023. And how will it inure to your benefit if this kind of vague direction, if there may be 2 directors or 6 directors, how does it help?
Let them come. I will pray for a shorter date, my lord. We can get, if it can be done before the vacation.
Shorter
And some-
date,
Shorter date, yes.
6 weeks for their affidavits of assets.
Great.
Next.
'61,
I'm for-
AD Electrical Products.
I'm for the award holder, my lord.
No, I'm for the
So, my lord, it's in respect of execution
Yes.
of an award passed by the MSME Council. Now, an application being GA number 1 has been taken out by my learned friend on the ground that they have not received. It's in the nature of section 47. It's not executable because they have not received a copy of the award. Affidavits are complete in respect of the application. We have, my lord, shown in by way of the affidavits that there is this specific postal receipt number, which is in respect of the letters issued by MSME Council containing the certified copy of the signed
You are
copy
the
of
buyer,
award.
Mr. Mukherjee.
Yes, yes. Now, my lord, the specific contention, my lord, which
One
I
minute,
read-
1
I'm
minute,
not-
please. Yes.
Now, that was, my lord, that was shown, my lord, and the whole issue was there whether it was actually received by them by way of that postal receipt.
Yes.
Now, by way of the last order, the coordinate bench, my lord, had directed that notice to be given to the MSME Council or information to be given to the MSME Council so that, my lord, all the documents pertaining to the arbitral proceeding can be brought before, my lord, before this court. Now, after this, my lord, we have, my lord, given a notice to the MSME Council. We have sought for clarification in this regard. There is a letter of the MSME Council, my lord. I'd like to file a
So
supplement.
they are not here. MSME Council is not.
We have given notice, my lord. And in fact, we have received a letter from the MSME Council confirming that the award was in fact forwarded to them by way of the particular specific postal receipt number, which has been sent to the judgment debtor.
Very well. We are in September now, so I will pass another direction on them to be represented.
Very well. My lord, may I file the supplementary affidavit bringing on record, my lord, the facts which transpired after the 24th April 2023 direction, my lord.
May I
Oh,
please-
the council was only directed
Yes,
to send the
to send the
documents, nothing else, nothing more.
Nothing else, my lord.
And the documents have been sent.
My lord, no, not the entire documents have been sent because they were supposed to send the documents to court. My lord, we have written a letter to the council and also they have handed over to us some documents, but not the entirety, and also a clarification that the postal receipt number, which, my lord, we are saying that they have received, it's actually the same postal receipt number by which the judgment debtor has been served with the award. So that clarification they have given, my lord, it is part of my supplementary affidavit, my lord, if lordship kindly takes it on record. It's at page 19, my lord, of the supplementary affidavit.
Yes, Mr. Mukherjee.
Yes, my lord, may I indicate one thing first? My lord, in this matter, your lordship will find the dispute is with regard to, my lord, whether a signed copy of the award has been given to us or not. My lord, I have taken a specific plea under section 31(5). Now, my lord, that is why this honorable court was pleased to call for the original records of the case. What my learned friend is relying on a letter which was unilaterally sent to them. The original records has to be before this court, my lord,
Very
that has to be
well, yes.
inspected.
Learned counsel appearing for both the parties agree that contrary to the direction given by a coordinate bench on 24th April 2023, the MSME Council, capitals, has not sent the entire records which are relevant for determining whether the council, whether the award debtor received a signed copy of the award passed by the council. Stop. Next. The correspondence, the petitioner's correspondence with the MSME Council is on record. Stop. The last set letter was sent on
Well, at 18th August 2023 is the letter.
the petitioner's, the last letter to the council was sent on 18th August, 2023.
The last letter by the council on 18th August, then we sent a letter on 21st of August again.
The last letter by the council to the petitioner is on 18th August, followed by the petitioner's reply of 21st August, 2023. Stop. Next, since substantial time has gone since then, comma, the MSME Council is requested to, is directed to send the entire documents before this court within, what is a good time, Mr. Bhattacharya?
My lord, within 2 weeks.
Within 2 weeks from today. Stop. The petitioner's advocate on record shall specify the documents which are not before the court by way of a letter to the council, which is to be sent by
My lord, we'll send it within this week, my lord, by Friday we'll send.
by 22nd September 2023.
And my lord,
Stop. Within 2 weeks, jeta bolam na, within 2 weeks from receiving the letter from the petitioner's advocate on record.
And my lord, liberty be granted to us, my lord, to inspect the documents, because my lord, that is the crux of the case.
Yes, list this matter on 10th October 2023. Stop. The respondent shall be at liberty to the award debtor shall be at liberty to inspect the documents in the meantime.
and the supplementary affidavit filed today be taken.
The petitioner supplementary affidavit is taken on record.
Grateful, my lord.
You're in the next matter. What is it that you want?
It's an execution application. I was praying for, since the decrease within 2 years, I was praying for order in terms of prayer A, a filing of affidavit of assets.
Actor, ye bar karo. What is the date of the decree?
17th May 2022.
Yes, the advocate on record of the decree holder seeks, of the award holder seeks execution of an award dated, award/decree dated 17th May 2022.
Order in terms.
Stop. Let a notice of the, let a copy of the application be served on the award debtor. Stop. Next. The award debtor shall file its affidavit of assets within 10 weeks from today. Stop.
In Form 16. Appendix E 16A.
In accordance with the prescribed format, namely Appendix E of Form 16A of the CPC of the Code of Civil Procedure. Stop. List this matter after 12 weeks.
This similar order to 4 matters.